First babysitters in all the court name.
All right, anything before the jury's brought down?
There was one thing, Your Honor, in regards to the exhibit that we discussed on yesterday.
One thing about the charge?
No, sir.
Oh, okay.
It was about the exhibit from yesterday that we went up there. When I looked at the exhibit list of,
The one that was introduced?
yes.
60 from the deposition?
No, sir. It was in regards to the text that we discussed at the end of the day yesterday.
That the state said we would have asked a whole lot of questions of your phone
Yes.
person. What about it?
You had it, I didn't understand yesterday. I thought that you were entering it, or were you just accepting for offer of proof?
Offer of proof
Okay,
marked
that's
with
all I
those.
need to know. Okay, thank you.
All right, let the jury step down. All right, good morning to you, ladies and gentlemen. Let the record reflect all of the jurors are here and present. In closing argument on behalf of the state.
Yes, Your Honor. You did this so something would happen to the baby. Jade Benning, she did not call 911. She did better than calling 911. Jade Benning called the one person who knew where she was, knew who she was with, would know that she was calling scared and for help. Now, Jade Jackson said as soon as she heard her best friend's voice, she knew she was scared and she needed help. Jade Benning did better. She made sure that Blaise Taylor was not the only person to hear her last words. She made sure that you heard her last words. She called Jade Jackson and said, Blaise, you're scaring me. Nigella heard him say, you're scaring me. I know you put something in my drink. I knew my drink tasted funny. Let me see what's in your pocket. Let me see. I know you put something in my drink because I can't even walk straight. I can't feel my legs. You put something in my drink. You did this so something would happen to the baby. I think I'm about to pass out. Jade Benning ensured that you heard her words. That night where she was so excited to be having a date night with Blaise Taylor. Her best friend came over. They were the only two people there. Dr. Aaron Carney gave a very specific medical explanation that Jade Benning would have gone pulseless within 30 minutes of ingesting that concentration of cocaine dissolved in a liquid. There were only two people there. The proof and testimony that you have heard over the last week from Jade Benning's family and friends, the pictures, the things in her phone, she was so excited to be having this baby. She was so happy and planning for her baby girl to be born. I submit to you that it does not matter how many questions were asked about fentanyl or cocoethylene. It does nothing to change the evidence and proof that you have that Jade Benning did not want to harm herself or her baby. She wanted the opposite of that. The proof and evidence from Nigella Jackson and Dr. Aaron Carney is proof beyond a reasonable doubt for counts 2 and 4 that Blaise Taylor intentionally put that cocaine in Jade's drink to kill the baby. And Jade Benning was killed when he did that. You also have the proof and testimony of Apple Denny. She described to you an event that happened several years before in 2017, but when she heard about what happened to Jade Benning and that Jade Benning was dating Blaise Taylor, she knew immediately. She reached out and contacted people because she knew she had information that it was him. She testified, told you about very personal things that happened to her, but she described what happened over a period of 2 days. Her testimony was she had to talk him out of putting something in another girl's drink who was refusing to have an abortion so that he could cause the abortion without her knowing. Blaise Taylor chose cocaine. He chose what to put in that drink. He chose a substance that you have heard from multiple witnesses is known to cause spontaneous abortions. Dr. Carney described that it is known to cause a placental abruption. And she also testified that that did not happen to Jade Benning. It did not happen because he killed her. I submit to you that there is proof and evidence that you have heard over the last week that proves beyond a reasonable doubt all 4 counts of the indictment, including the first-degree premeditated murder of Jade Benning. Blaise Taylor chose this. You saw when he got back in touch with Jade Benning, they had a conversation that explained what happened back in November of 2022. This is kind of a somewhat joking conversation, but Jade Benning said, "You gave me a crazy ultimatum." Apple Denny testified to that same ultimatum. You have Jade Benning's decision to the ultimatum he gave her. She chose her baby. She did not choose Blaise Taylor. She did not make the choice that Xavier Winford made back in 2017. She chose her baby. Apple Denny gave that same description of the ultimatum, and you have that there was no contact from November 6th to December 31st of 2022. Jade Benning was planning for her baby. Her life was going on. But you also heard from her family and friends that during that time, she was not posting anything about her pregnancy to social media. She had not posted anything to social media about her pregnancy on the day she was murdered. It was not publicized. When Blaise Taylor comes back into Jade Benning's life, this is the evidence that you heard was not he came back welcoming this opportunity with open arms. He tells her very specifically in these messages that your life is changing. This is going to be a thing for you. At no point does he say we, me, ours. This is going to change Jade's life. And he is not portraying it as a positive, telling her she shouldn't be so optimistic. And Jade Benning, just as her friends described her, always optimistic, still said, okay, but I'm going to be able to make this work. Blaise Taylor did not go to any of her pregnancy appointments with her OBGYN. Not one. She asked him very specifically, sending him the calendar event. And specifically saying, I really hope you can make it. I would love for you to be there when I found out the gender of our baby. If it's going to be a boy or a girl, I want you to be there. And he did not go. And even when they saw the shadow and she had to have follow-up testing and then another follow-up appointment, he didn't go to any of those. Jade's stepmom, Andrea, she went with her the day that she found out she was having a baby girl. And Jade was still so happy even though he wasn't there. You also have proof about why Jade wasn't posting, about why everybody didn't know that it was his baby. He was the father. You have a message where Jade is saying, I talked to my mom and let it be known not to bring up you or my situation to anyone. She is defending him and his request that no one know that he's the father of the baby. He responds, but it's all good as long as we are on the same page moving forward. Everything is cool, but I appreciate it. The day before Jade Benning is murdered, the day before, the night before she is murdered, Jade Benning wanted to see Blaise Taylor that night, and he didn't. He is texting Xavier Winford, who he's had some kind of relationship with since 2017. He's texting her and saying, you should never doubt anything when it comes to us. And she says, I'm doing my best. And he says, I know, I'm trying to reassure you. She thanks him. He says, I'll do anything to help you. That's what I'm here for. She says, I trust that's true. And he says, good. Do you trust in us? She responds, yes. Good. Then you have nothing to worry about. Everything is going to work out. She says he's glad. He says, me too. I love you. And I need you to love me back. And be in love with me. She responds that she loves him, and he says, good, I just want us to be happy together. We are going to be just fine. We just need to stick together. And she promises him that they are going to stick together. The next night, he goes over to Jade Benning's house for date night. The date night that she's planned. She has canvases so that they can paint pictures for the baby's room. He goes over there to the date night with cocaine to put in her drink. He goes to the date night. The testimony that you heard from Nigella Jackson and from Keontae Jones about them stopping by, that whole time that he's shuffling those Uno cards, he has the cocaine to put in her drink. He gets there at 7 p.m. They show up at 7:30 for 30 minutes talking about spades and having random conversation. And he has it. He does not call 911 until 9:29:27. I'm sorry. The call that Jade makes is at 9:29:27. EMTs don't get to her until 9:50. Dr. Carney's testimony is that Jade was given the cocaine that she ingested orally 30 minutes before. You have this photograph from 8/29 that shows the progress. She has not been given anything at that point. The next image that you have is at 9:10 p.m. It is somewhere between this point and the next image of their progress that she has to have been given the cocaine in her drink. – 9:24 p.m. is the next time that there is an event. It is after that 30-minute mark. She has finished the painting. You heard Dr. Carney's testimony about how the symptoms would start off not severe, but it would escalate really quickly. And 9:24 to 9:28, you have 4 minutes. 4 minutes after he has put this in her drink. He is there and knows what he has done. And for 4 minutes, takes picture after picture with Jade Benning. Blaise Taylor went there with a plan. There was a plan. He has already poisoned her. and he is taking pictures with her. Blaise Taylor did not plan for Jade Benning calling Najee Jackson. That hadn't happened yet. The last event that happens is that deleted picture, and within 45 seconds, Jade is calling her best friend. What did you do? She is calling her best friend scared, and she is not talking to Najee. She is talking to Blaise Taylor. 6 minutes and 9 seconds. He is there. Jade is telling him, I can't feel my legs. I can't walk straight. He is there, and he is not saying anything to her. Like, Jade, what is wrong? What's going on? Let me help you. Come on, sit down. What is happening? You seemed fine just a second ago. What can I get you? Do you want me to call someone? You didn't hear testimony of any of that from Najee Jackson. You also heard Blaise Taylor tell Detective Smith that third interview. He was describing what happened that night, and he said that Jade was trying to lay down. He didn't tell him, so then I helped her. He says that Jade was talking to him. Talking to him. And then he says she wasn't saying stuff right. Maybe she was kind of talking to Najee. Now, at this point, when he tells this to Detective Smith, Najee Jackson has already told everybody exactly what she heard her best friend said. She's told the people at the hospital, the first officer, the second officer, the detective, family and friends. She's told Blaise Taylor to his face, like, you didn't tell them what she said. He stood there for 6 minutes and 9 seconds knowing that he put cocaine in her drink and she drank it. Well, she said these things to him of, I know you did this. Stood there for 6 minutes and 9 seconds and did nothing to help her. At some point, Blaise Taylor figured out that Jade called Najee. He tells Detective Smith that he was there when she called her and that he spoke to Najee on the phone. And Jade told Najee she wanted her to come over. Najee Jackson's testimony was unimpeached about what she heard her best friend said and about what happened that night. Blaise Taylor did call 911. He did. But he already knew that Najee had been on that phone call. Because this is before Najee has gotten back to the apartment. She hasn't told anyone she heard what he said. She hasn't called him. She doesn't call him until 9:47:11 when she calls back to Jade's phone. That's when she talks to him. But 5 minutes before that, after he's called 911,
No. If you look up the title, I think one of her friends is on the way. Okay. You right there? No. If you look up the title, I think one of her friends is on the way. Okay.
is telling the 911 operator that one of Jade's friends is on the way. He hasn't spoken to Najee Jackson yet, but he already knows she's on the way. I submit to you that call to 911 by Blaise Taylor is because Jade messed up the plan. He knew Najee was coming. That's why he called. And even then, after 6 minutes and 9 seconds of Jade Benning's last words on earth, he doesn't even call her immediately. He doesn't call 911 immediately to get her help. He waits 2 minutes and 37 seconds, and then he calls his dad, which that's a 30-second phone call. There was no testimony as to whether or not that call even got answered. It's 3 minutes and 28 seconds after that call with Najee ends before he calls 911. There was no cup with any cocaine that was collected in that apartment. There are 3.5 minutes before he calls 911. You do have his statements with Detective Smith. Blaise Taylor tells him, oh, there's no alcohol whatsoever. No, 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 no. And we both drank the same stuff. And then he's asked if he cleaned up, and no cleanup. He says that Jade cleaned up some. There was some cleanup by her, but he was not cleaning anything in the apartment. And when asked if they went back and got the glasses, if the lab would test positive for anything, and he said no, it won't. Now, there's at least 2.5 minutes before the 911 call, and that's just the call to his father. There's this time of what's happening. This cup ends up over by the sink. Detective Reese testified that it appeared it had been washed out. The camera, that is after Najee Jackson moved the camera back to where it normally would have been. This is from 3 days before. This is what the camera would have captured. If someone went over to the kitchen island and did anything to any of the cups, it would have been on that camera. But that camera was not where it normally was. When her friends, thank goodness, went to her apartment to secure it and make sure that the evidence was collected, that's where they found the camera. In her bedroom with the blinds up, in a place that would not capture anything that happened to Jade Benning on her bed and anything that happened in the kitchen. You notice the selfies that they took for 4 minutes while the cocaine was clamping down on her blood vessels before it could make her heart stop. They were all off to the right, not in that camera angle. The 911 call that happens 3.5 minutes after the call to Najee ends, listen to the call and where he is.
February 25, 2023, 21:38 and 58 seconds.
911, what is the address on Ronald since they're selling your binder? I don't know. It's an apartment complex. Is there a nail with it? With the address? I'm looking around. Just give me a second. I'm looking around. I don't know what's going on. I think she did give me 1 second. Okay, are you on Donald tonight or are you on Lebanon here? Lebanon? Yeah, Lebanon. It's apartment 107. Or is it 1540 Lebanon Way? I don't know. It's not Burger King. I do know that. I'm going to the apartment building to get the condo slash apartment. Yeah, sometimes it's name of okay, is there a backhoe on the corner there, sir? Is there what? The backhoe on the corner? I'm not sure. I just passed it. I'm going to the Ontario 1522-1550 Lebanon Pike, the Ontario. 1522? Yes. The Ontario 1522-1550 Lebanon Pike. So the Ontario 1522, she's in apartment 107, and she's having an overdose, is that correct? I don't know, I think she's having a allergic reaction. We were eating cookies and pain, and she said she wasn't feeling it, and we went back to the room to check on her.
I'm running back to the room to check on her. He's outside. It might not be the pink cup by the sink. He's had all of this time. He's running around outside. He's not there with Jade. He told the first officer, the second officer, Detective Smith, everybody. She threw up, called my dad. He told me to hang up, called 911. He is running around outside, not even with her.
And what's the case you disconnected while you're getting up there? What's the callback number in case you disconnected? This number right here. Is it 8 number 773-5738? Yeah. Okay, now what is it? 23, 24. Okay, is she awake right now? Yes. Okay. And you think she's having an allergic reaction to food? I don't know. We got cookies and pasta. I don't know what she's done. If she's done anything today or anything, but everything was fine. And then I don't know what's happened. So we got stick coming out of her mouth and she's shaking. So you think possibly a reaction to not knowing food? Is that correct? I think so. I don't know. Okay. I don't think she's allergic to anything. I don't know. Okay. She is or not. It could be an allergic reaction. So are you next to her? Yes, sir? Yeah. Okay. Does she appear to be breathing normally? Yeah. Okay. Does she have any difficulty swallowing? I don't know. I'm not a doctor. No. I'm not okay. Is she recovering more?
It sounds like she's snoring. Dr. Carney explained that that's agonal breathing, that she is very close to full cardiac arrest. Mr. Taylor describes her as being breathing and conscious the entire 911 call. I submit to you it's unclear if he is giving any information as it happens or if he's just describing what's already happened. He calls 911 knowing that Nigea Jackson is on her way and she is going to find Jade Benning pulseless. He called knowing what he gave her. When they found her, She is face down on her bed, her mouth on the comforter with pink vomit that tests positive for cocaine. I submit to you, it doesn't matter what was in the drink. It doesn't matter if there was something else mixed in with it. That doesn't matter. The proof and evidence in this case is that Blaise Taylor put whatever it was in Jade Benning's drink. He did it and then stayed for 30 minutes. He did it thinking he would be the only one that would hear her words. He did it thinking you would never hear her words. Jade Benning said, "You put something in my drink. You did this so something would happen to the baby." Blaise Taylor is guilty of the first-degree murder of Jade Benning. He is guilty for the first-degree murder of her unborn baby girl. The proof and evidence in this case proves that beyond a reasonable doubt. He is guilty of both counts of felony murder because he chose to give her cocaine, he chose to put it in her drink, and he chose to kill both her and her unborn baby girl. And we will ask that you return a verdict of guilty on all 4 counts of the indictment.
Closing argument on behalf of Mr. Taylor.
Yes. Good morning. Standing here at the end of the trial and trying to put everything together is always, for me, very difficult because the burden is always very heavy. And your jobs are never, it's just never easy. Never easy. But we're here. And one of the things that I want to talk to you about is the words that you guys gave us. Not just me, but the state as well. Not just Mr. Taylor, but Jade's family as well. No matter what happens as a result of this, it is still a tragedy. It is still a very awful incident that occurred. And there is only one question that we have to answer. Is whether or not Blaise Taylor, in your minds and in your opinions, is guilty beyond a reasonable doubt. There is only one question or one thing that we will ask of you, that I will ask of you, that Blaise will ask of you, that his family will ask of you. And that is to keep your word. Keep the word that each one of you gave us. And that is that you could follow the law. You cannot, we cannot build a justice system based on emotion, based on sympathy, based on just the mere fact that a tragedy occurred. Every time a loved one leaves this earth, it is sad and it is a tragedy. But that in and of itself cannot drive our justice system. What we cannot do is say, because someone lost their life, that we don't have to follow the law, that we don't have to hold the state to its burden, because otherwise this system collapses. We could talk about the pain that a mother feels when she loses a child. We can talk about a beautiful young lady and her daughter who is no longer with us. And if you're not human, you won't hurt. But if you are human, you will hurt. But that should not play into your decision making. In order for this thing that we call the Constitution to work, you have to set that aside. And that's the word that you gave us. That's the oath you swore to take. There is a burden here. And I bring it up because that's why we're here. I'm not bringing this up as a facade. I'm not doing that. I'm just reminding you what the law is. I'm just reminding you what governs this trial. Every defendant has a Sixth Amendment right to a fair and impartial trial. Every citizen charged with a crime should get a fair and impartial jury trial. And at the end of the day, when those jurors make a decision as to whether or not he is innocent and or guilty, they must use that burden of proof. And they must hold the state to it. What you can't do is say, well, then what happened to her? If he didn't do it, then what happened to her? Well, I don't know. Well, I don't either. Well, then he must be guilty. Because he didn't prove to us that it wasn't him. But remember, we don't have to do that. That's not the burden. They must prove to you what happened to Miss Benning. They must prove to you beyond a reasonable doubt what happened that night. Not us. Not the defense. So then you ask yourself, well, what happened? If he didn't do it, what happened? You're going to say that a million times because that's just a natural reaction to what we're dealing with. But remember, as you are going along that journey, deliberating back there, going through the evidence, remember, they must prove it to you. You cannot ever place that burden on Blaise. You cannot. The minute you do that, that Sixth Amendment right to a fair trial collapses. And once that collapses, the system collapses. And once the system collapses, you have people wrongfully convicted and sitting in jail for a very long time, trying to prove their innocence. And that's not the way it was designed to work. That is not the way our forefathers meant for it to work. So with that being said, let's talk about it. Remember, as we came in here on June 22nd, 2026, we dealt with an official finding of undetermined, the manner of death in this case, by the state's own medical examiner. She had the option to choose homicide. She knew the facts. You heard from Dr. Carney way before you did. And she couldn't figure out what the manner of death was. She landed on undetermined, and she's still on undetermined. Now you're tasked with whether or not you can take it over the hump and move it to murder beyond a reasonable doubt. I want to talk to you guys first about the facts of this case and what you've learned since you've been here. What I don't want you to do as we take this journey is come into this environment and say to yourselves, I want to live in la la land. I want everything to be perfect. Life isn't perfect. And the older you get, the more you learn that. The older you get, the harder it gets. Trust me when I tell you that. And those of us over the age of 50 can tell you about things that we experience in life that are good, that are ugly, things that we've learned along the way. How we treated people in the past, how we interacted with people in the past, how we respond to people in the past, and how we respond to people now. You learn along the way. But what life isn't is a perfect cookie cutter la la land. That's not life. So let's talk about Blaise and Jade. They met on Hinge. They dated for a little while in terms of, I shouldn't say date, they interacted for a little while, but never really met up. And remember, these are young people. They had casual relationships, not just with each other, but with other people too. And it wasn't just Blaise that dated other people. They both dated other people. They were adults. They were consenting. Nobody did anything wrong because everybody agreed that you can date someone else and you could date someone else. We may not want to live our lives that way, but that's the way they chose to live their life. So when you hear the facts about Blaise texting someone else, that was nothing against Jade because she was okay with it. So don't let the state make you think that because he was dating someone else and he texted that other person, that was something nefarious or wrong. It wasn't. He didn't have to hide that. She knew that. Najee told you that. She said it to the police officers. She said they weren't dating like that. They weren't exclusive. So no matter how many times the state tells you that Blaise was texting another woman, there's nothing nefarious about that. And that has nothing to do with whether or not he committed murder. So don't go down that road trap. Stay focused on what you're here to do. And I want to be clear when I tell you that when we're talking about facts, if you remember, in voir dire, I had a slide up, and it had facts and blame. And I asked each one of you, would you be okay if sometimes facts were ugly, but I needed to share that with you so that you could have all the facts to come to a decision. It would be unfair to Blaise if you didn't have all the facts. So don't think that those facts that we're putting before you are there to put blame or shame on anybody, because it's not. But it would be unfair for you not to have all the facts so that you can come to a conclusion, one that makes sense based on the evidence in this case. Because that's how you get to a solid verdict, is because of evidence, not of sympathy, and not of being angry because I want to give you facts. That's all I want to do. So when they're dating in this casual relationship, they knew each other for less than 90 days. That's a fact. They met up in August, and before the end of the month, they were having sex. That's a fact. And they were having sex without a condom. That is a fact. And we know that because otherwise she wouldn't have been pregnant and thought it was Blaise's. So when she finds out that she's pregnant, she and her best friend are trying to make a decision about who the father was. Because at that time, she wasn't sure. And we talked about that with Najee. And to me, I think that that is a crucial fact for you to consider. Because if she wasn't sure Blaise was the father of the baby, neither was he. So you would then have to believe that he would kill her and that child, not even knowing if it's his or not. That's a fact. And so she tells him she's pregnant. And he's not happy about it. She is. And that's great. There's nothing wrong with that. But Blaise, on the other hand, with only knowing her for 90 days, maybe he's not happy about that. I guarantee you he is not the first human being that in his 20s had a unexpected pregnancy pop up and he's not happy. I guarantee you he is not the only human being who's ever felt that way. And they want you to believe that that's just a horrible fact that would give him motive to kill her and the baby. Most folks in their 20 years, who is in their 20s, who get someone pregnant that they don't know within 90 days, I'm willing to bet at least 50-50, are not happy. That's real life stuff. That's not a nefarious fact. That's just real life stuff. And that's what I'm going to talk to you today about, is real life stuff. Because if you remember, you heard from Najee, they were talking about possibly going to Indiana for an abortion. Remember Najee was saying it was 2 weeks, 8 weeks, you better make a decision and make it quick if that's what you want to do. And she said, yeah, I do. I need to make that decision. You heard that testimony. Eventually, she landed on having the baby, which she has every right to do. But somehow, it's okay for her to consider abortion. But it wasn't okay for Blaise to consider it. That's not fair. Don't let them turn that into a nefarious fact that will automatically get you over to murder. They both considered it. It was just her window was shorter than his. 'Cause. 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 ' for you to punish him if you don't punish her. So at some point, they talk about it. Apparently, Blaise was still in the position that he was in, even though she had changed her mind. And she, with the strength that obviously she has, or had, said, look, I'm not changing my mind. You've made your decision. If you don't want to be part of this baby's life, kick rocks. I'm good. And he said, okay. You don't see after that, because Najee, I asked her those questions. You don't see after that Blaise constantly calling her, trying to convince her to have an abortion, trying to manipulate her into having an abortion, blowing up her phone, smoothing her out. Because if ultimately his plan was going to be to try to kill the baby, it would have made way more sense to do it up front than wait till she's almost 6 months pregnant. Why would you wait until somebody gets 6 months pregnant if that was your plan all along? Remember, she came back in contact with her, December 31st. So he's going to drag it out and let that fetus get 2 months bigger? That don't make sense. He could have done that a whole lot sooner. That would have made sense. That would have been easier. A miscarriage within the first 90 days, that makes sense. Some people don't even tell people they're pregnant for the first 90 days until they're sure that they get past that first trimester. But he'll wait until she's 6 months? So she makes a decision. She says, you go your way, I'll go mine. And he honors that. He honors her wishes. Now, if he was cooking up and stirring up this evil plan, why wouldn't he start the manipulation right off? Najee told you that she liked him. She wanted to be with him. So it would have been easy for him to do that. But he didn't. And I think that's a very important fact. Because if you remember that text message that they read, to you, I want to remind you of that text message. This is Jade. Remember, they read this to you. Next time I'm tagging along for the adventure. LOL. Blaise says, LOL, okay. That's if you want, of course. This is Jade. LOL. He says, gotta still have a job first. And second, you probably ain't doing much traveling for a while anymore. When next season rolls around, I don't think you'll be able to just make impromptu trips on the weekends, considering you'll have other responsibilities. Not trying to be negative or nothing, but just being realistic. I mean, it would be great if you could, but it's unlikely. What does that mean? That means next time this year, you're going to be a mother. She's 23, 24 years old, 24. You're going to be a young mother. And that comes with a whole lot of responsibilities. So start getting your mind right. And if that's going to be the mother of his child, let me give you a little advice. Men who handle their business, they want women, the mother of their children, to handle their business so that they can set a good example for the child that they're raising. Don't let the state turn that into some kind of, oh, he was so mean. No, he was telling her the truth. And those of us that are mothers, we know the responsibility it takes to raise a child. There are often times you miss trips because you got to stay home with your child. You don't get to go away like you used to when you're single. You need to start thinking about those things. The lifestyle that you live, hanging out with your friends and drinking and having a good time, that's going to change. And that's what he's telling her. Not to be mean, but to be real. What's wrong with that? Then he goes on to say, or she says, LOL, okay, didn't mean to make it all serious, but yes, responsibilities will be different, but living life will still be happening as well, just living differently. And I understand the realistic thinking of it as well. It's part of the big change, she says. And he says, yeah, especially for you. I remember getting pregnant. And my mother said something I'll never forget. It goes a long way. She said, honey, that's going to be your baby. Because it's nothing like a mother with their child. Daddies love their children, yes they do. But they don't love them the way the mother does. That mother gets up every morning. That mother got to comb hair. That mother has to get that child out there. And yes, the father should participate as well. But the reality of it is, men don't come close on the daily activities that a mother does with their child. That's real. It's probably something he saw every day with his own mother. And she says, of course, wasn't trying to get into a serious talk for us, sorry. He says, but we don't got to be super serious. I just didn't want to sell false dreams because, yeah, it would be great if you could come on my work trips. But I just feel like it's not realistic from a financial or just a feasible ability to randomly catch a flight and get away for a weekend. We're young. Money's already tight. We can't just spend money on getaway trips on the weekend and this baby is coming. And I could lie to you or I can keep it real with you. Blaise wouldn't have been able to win here. It didn't matter. If he would have sold her a dream and lied to her on here, they would have been telling you that. But now he's keeping it real with her, being honest with her. And now that's wrong too. Would you rather him lie? The man was trying to be honest. The man was trying to be responsible. And somehow, that's wrong too. It's no big deal. I know you wasn't meaning it that way, but I just didn't want to be like, oh yeah, I'll bring you on the next one, next year knowing that it's probably a lie. She says, totally understand, babes. It's not like it can never happen because I'm having a baby, but realistic, it wouldn't be able to on the fly. Planning out things will always be an option. Life doesn't just stop because of it though. Laugh out loud. We're still going to have one, just living different. He says, I hear you, but you can't minimize how much things are going to change for you. You've got to be realistic that things are about to be hella different for you and will change drastically. Your day-to-day life is not going to be the same. Yeah, life goes on, but it's forever altered and changed in a drastic way. I'm not saying it's over or anything, but it worries me sometimes when you downplay it and act like it's no big deal. And I know you always want to be super optimistic and stuff, but I feel like you need to be honest with yourself about the situation and know what's down the road for you. Now let's back up with that. He says, it worries me sometimes when you downplay it. That means there's something that has gone on in the past that has caused him, with the woman who is potentially going to be the mother of his child, to start having serious conversations with her. Hey man, let's plan this thing out. Start thinking right. So there's something going on there that made him feel like he should have this conversation with her. If that's going to be the mother of his child, what's wrong with that? In fact, that might be good. And then he says, I just want to make sure you understand the gravity of the situation and you're preparing for those realities. That's all. She says, I'm not trying to minimize things, and sometimes I can be super optimistic. She's admitting to it, about things which can be scary. But I do sit and process that there will be drastic life changes and prepare myself for the tough realities as much as I can that are to come. I'm not just trying to make it seem like everything is going to be all peaches and cream. I am hearing and understanding everything you are saying. He liked it. And then he says, hey, what time are you going to work? She says around 3. So she wasn't upset about the conversation. And if you remember, Mr. Devlin, when he was testifying about some of the text messages between them, do you remember when she said that it turned her on when he talked serious with her? That's what this is. That came out of her mouth. It turns me on when you talk serious to me. Some people like to date people and be with people that motivate them to be their best. People who hold their feet to the fire. Iron sharpens iron. And I always say, I never want to be the smartest person in the room, because how can I get better? So when you're attracted to people who are responsible, and that's who you attach yourself with, you're hoping that it makes you a better person. All of our parents have told us, watch your friends. Watch who you hang out with. Look at the 5 closest people in your life, and you'll see your future. So she wouldn't have said that she's turned on by having serious conversations with him if she wasn't. And so that was the nature of that conversation. Now, there was so much talk about how Blaise just totally disregarded the baby, totally disregarded her pregnancy, as if he was just pushing her off to the side, waiting for the perfect moment to kill her and the child. Because if you notice the tone of that text message conversation, it was talking about the future. Why talk about the future if your plan is to kill her anyway? You wouldn't even have to have those conversations. You could just continue to make her feel peachy and creamy. You don't make plans and you don't try to help the person become more realistic about what it takes to be a mother if it's not your intention for her to be a mother. That doesn't even make sense. So I wanted to show you a few things, because we didn't get to show you everything in the phone, because if you remember when I asked Mr. Devlin, was there a whole lot more in there? He says, yes, we only provided a sample. So some of those text messages were, Blaise told me last night he signed up for monthly subscriptions of diapers from this company, Kudos, LOL. Why would he do that if it was his intention to kill the child? Didn't you ever state at occasion you knew that he and Miss Benning talked about naming the baby Jim? Do you remember when I asked Najee Jackson that? And she says, yes. I said, well, that would be involved with the baby, wouldn't it? She says, yeah. Because remember, her name is Jade, his name is Blaise, and so they were going to name the baby Jim. That's being involved. It may not have been to the level that she would have wanted it. And I guarantee you yet again, if we're talking about real life, there's a whole lot of women out there who would love for their significant others to be a little bit more involved with the child. I certainly know that I would. Here, does Blaise rub your belly? LOL. Sometimes. If he's planning names, buying diaper subscriptions, and rubbing her belly, then what we're really talking about is that he wasn't doing it on the level that maybe she wanted it. It wasn't that he wasn't doing it at all. Let's go now to the day in question, because we know how they've met, we know how they dated, we know what the understanding was, we know they both considered abortion at one time, one changed their mind quicker than the other, they got back together, they're having realistic conversations, and remember I told you about before, during, and after. Because no one saw Blaise put cocaine in Jade's drink. Nobody saw that. That's undisputed. Nobody saw Blaise give her alcohol. And we're going to talk about that a little later. Nobody saw that. So what that means is this is a circumstantial case. And in order for you to come to a conclusion that is proper in a circumstantial case, because those are the most dangerous ones, because nobody sees what happened, you have to consider all the surrounding circumstances. Most of the time, the crime is in the cleanup, and I'm sure you've heard that before. So you have your before bucket, your during bucket, and your after. What we do know, and like I said, I'm not doing this to shame anyone, because if I was, I would have a ton of text messages up there about drugs and all kinds of stuff, but I'm not doing that. The only reason I'm sharing this information with you is so that you can have the facts as they really are. So when we talk about before, there was only one person involved with drugs, and it wasn't Blaise. You didn't hear any evidence of Blaise purchasing cocaine, smoking weed, doing mushrooms, getting drunk, drinking alcohol. In fact, it was the exact opposite. The evidence you heard is that Blaise does not drink and does not do drugs. However, what you did hear is that Jade does drink to the point that she gets drunk, and she does drugs. So that's before. Remember, this is circumstantial, so you consider all the facts surrounding it. Jade invites Blaise over. This is important because Blaise didn't know that Jade was going to invite him over that day. He had just seen her the day before. Remember, they had gone to the Waffle House. So there were 2 days before that he was with her, that he could have pulled off the elaborate plan, but he didn't. And so spontaneously, she invites him over again. This is the third day in a row now. And so you see here, Also, will you be free around 7 o'clock? Yeah, I fell asleep watching Outer Banks, then woke up to gun firing on the show. But yeah, I should be. LMAO, woke up confused, ASF. Okay, I'll have plans for us. You can come dressed, comfy to my house. Okay, sounds good. Sweet, I am getting off now, she says. And that is at 3:50. And he says, how was work? So now this spontaneous plan is 3:50. He has 3 hours to cook up the elaborate plan to kill her. Because remember, he didn't know she was going to ask him to come over that day. So he comes over. When he comes over, it's 7 o'clock. He's there. And then Nigea and Keontae shows up. He didn't know that, right? Now, if all the while it was his plan to kill her that night, you would think that once Keontae and Nigea showed up, if he had any kind of sense, he'll abort the plan. But no, he's brazen. Even though her best friend came over, saw him in the apartment alone with her, almost 6 months pregnant, 25 weeks, I believe the autopsy said. He decides, I'm going to go ahead with the plan and kill her anyway. I know they saw me in here. Doesn't matter. I'm going to do it anyway. And so they eat. Nigea and Keontae, they come, they talk, they interact. He invites them to stay. He invites them to stay. Why would you invite them to stay if it's your plan to kill her? So you can have witnesses? No. So they stay, they talk, he's shuffling Uno cards because the murderer who doesn't drink or do drugs plays Uno and then kills pregnant women on his downtime. And then they leave, and then they talk and they dance. They take selfies, and then the call comes. It's 9:29. The first call from Nigea. And the reason I wanted to lay this out this way was because there's been so much talk about this elaborate cleanup that he must have done. And I wanted you to see that there was no time for that. Because now we're in the during phase. And so 9:29, Nigea calls, and that call lasts 6 minutes, 9 seconds. That takes us to 9:35 and some change. And I think the interchange between that time and when he calls his father at 9:38 and 12 seconds is about 2 minutes. Now, mind you, Jade is having a medical emergency. All kind of things are going on. She's foaming at the mouth. She's shaking. She sounds like she's snoring. They tell him to get a towel, go wipe her mouth, put her on her side. He's trying to tend to her. But he's being punished for that. And if he wouldn't have tended to her, he would have been punished for that. But even still, as he is calling, or in the call at 9:29, when Nigea says that she's saying, you put something in my drink. What did you put in my drink? Do you remember the text message that Nigea sent as a result of hearing you put something in my drink? Are you talking to me? I want everybody to think about your best friend. And your best friend calls you on the phone. I want you to envision that. And you pick up the phone and you say hello. And they tell you on the other phone, you hear, you're stabbing me. You're shooting me. You're killing me. Are you going to say, are you talking to me? You know they're not talking to you. You're going to say, what's wrong? What's going on over there? Do I need to come get you? Do I need to call 911? That's a natural response. But instead, you send a text saying, are you talking to me? Remember, nobody else heard exactly what was going on that phone call. Nobody, but Najee. So let's look at the facts surrounding that. As much as she says that this was the worst thing she's ever heard, her friend was in so much danger, so much distress. It was horrible. It was scary. She knew, because she just left there, she knew that he was in that apartment. She was in that apartment alone with the man who was trying to kill her, according to her. But she doesn't call 911. Instead, she calls Keontae, who only met Jade twice. And apparently he gets on the phone. They're talking. At least he says he could hear her trying to talk. So if she's trying to talk, Dr. Ola Sugar told you she has to be breathing in order to do that. Remember, Keontae actually said he did hear her voice. But even with that, as dire straits as Najee explains that it is, he goes out with his buddies anyway. Think about that. If it was as horrible and dangerous, why would this guy put his clothes on and go on out anyway? And then remember, Najee, immediately after hanging up, called Jade's mom and shares with her what she heard, what Jade said. And notwithstanding that, Jade's mom sends Blaise a text and says, oh, the baby's good, the heartbeat is okay. If it was as serious and people believed Najee or believed in the credibility of her, do you think that Jade's mother would text that man and tell him and give him an update about the baby? Are you going to text the man who's just been accused of killing your child and give them an update about the baby? Are you going to do that? There's something not right about it. But that's what happened. And so, right after that phone call, he calls his dad, on the phone with him for 30 seconds, because that's what he told the police officer, that he talked to his dad, and his dad said, call, son, hang up with me and call 911. What are you doing on the phone with me? He does that, and within 16, so if that call lasted 30 seconds, that takes us to 9:38 and 42 seconds. And at 9:38 and 58 seconds, Blaise is on the phone with 911, and you heard that call. You heard the desperation in his voice. He didn't know the address to give the man. You remember that interchange. So the only way to get the address would be to run to the front to get the address. And if you remember what he says, I want you guys to pay attention to this. He said the address is 1522-1550 Lebanon Pike. Most of the time when people give an address, it's only one numeric value. It makes sense that he ran to the front of the apartment or the condominium complex because that's the exact address he gave them. So then, after that, I'm sorry, I went the wrong way. Then he gets off the phone with 911, and she calls back. So if it was 6 minutes the 911 call was almost 9 minutes. So that would take him right around to 9:47, and Najee calls back to Jade's phone. And he answers. He didn't have to answer. It was Jade's phone. He could have said, I was dealing with an emergency. But he picked up the phone. and gave her an update. Doing the responsible thing. Then after that, that call lasted about 2 minutes, she says. That takes us to around 9:49. EMS arrives at 9:48. And if you look at that slip from the EMS, because you'll have the right to look at the evidence, it's going to show you that EMS arrived about 9:48. And you heard him say, I can hear the sirens. I think I can hear the sirens. And then he goes out and runs to get them. Remember, on the call, the man says, put her on her side. So he did that. Then if you remember, as much as she didn't want to, she told you that Blaise ran out to meet them, at least at the door. So perhaps she rolled over while he was gone. We don't know. But nobody's calling 911 and doing all those things to help, only to put her on the side and try to kill her. So by now, EMS is there, so the time for cleanup is gone. Where was all this time for him to clean up? It's not there, because remember, those selfies was less than 60 seconds before the emergency call. The time just isn't there. So that's during. So when we think about during, there was only one person who called 911. Only one. As sick and as dangerous that it was described to be, only one person called 911. Frantic, running to get the address, doing everything that he could do. That's during. Now let's talk about after the investigation. Listen. What's unfair is 3 years later, Blaise is now held responsible to try to prove himself innocent, when one, that's not the law, and two, a lot of the evidence is gone. That's unfair. How can I prove my innocence when Detective Reese said he let the video surveillance camera get erased? How does the lead detective not get that surveillance camera that would have showed Blaise coming and going, Najee and Keontae coming and going? If he really ran to the sign, we would have seen that. If he came there with something in his hand, alcohol and or cocaine, perhaps we would have seen that on the video. If somebody else showed up there that day, perhaps we would have seen that. But they allowed it to get destroyed. Blaise didn't know that. Remember, he didn't get arrested for a year later. If he knew the burden was going to be shifted from what the law was, then maybe he would have done the investigation himself. But he was trusting the police to do the investigation, because that's their job. And we know that she met with the drug dealer that day, albeit it was for Mario or whoever it was for. If this is a drug overdose, I really want y'all to think about this. If this is a drug overdose, why wouldn't the police officer go talk to the drug dealer? If it was a financial crime, you chase the money. How in the world, in a drug crime, you don't bother to speak with the dude who sold her drugs that day, whoever it was for, whether she met up with him or not? That's not for us to have to figure out. But he didn't. So now you don't talk to key witnesses. And there were other drug dealers in her phone too. They didn't call any of them. You let the surveillance video get destroyed that possibly could have exonerated him. But we'll never know that. And now he will be punished for it. You let the cup that was supposedly the missing cup, the crime scene investigation team, they didn't see it. It was on the counter. Somehow we missed it. But all along, there was this missing cup that Blaise must have taken, because he cleaned up. We already seen there wasn't time to clean up. And he had taken the cup with him. The whole time, Detective Reese had to tell you, we missed the cup. It was there the whole time. Well, perhaps if Blaise knew one day he would be sitting here facing felony murder charges, he'd have had the cup tested himself. But he can't do that now. And he shouldn't have to do that now, because that's not the law. That was their job. And if it was cocaine in it, they would have known it. But they did take a bunch of glasses. They took all kinds of things from out of their dishwise, and there wasn't anything on it. Anything. And think about this. Remember how they talked about all this cocaine? One thing they cannot get away from is that she had cocaethylene in her system. They can't get as much as they would love to. They told you first it was coming from vanilla extract. Don't do that. Don't believe that. Or two, because of some of the treatment she got at Vanderbilt. There is no treatment at Vanderbilt that leaves you with cocaethylene in your system when cocaine and alcohol come together. That means, think about this, that means that he would have had to put cocaine and alcohol in either her water or her lemonade. And the chefs have sensitive palates. They taste food. That's what they do. They'll taste something and they'll tell you what ingredient is in it because they're trained that way. She didn't taste alcohol or cocaine. Neither one of them. And the amount that they're saying that he gave her. Does that make sense? How do you do that? How do you put that much cocaine in somebody's drink and alcohol, and they come out saying it tastes funny? It's going to taste a whole lot worse than just funny. You're not going to keep drinking it. And according to the state, it was so much that it caused this overdose. So she kept drinking cocaine and alcohol, the chef, and never, ever noticed it? No. So then we go to the fact that Lauren Weber went to the scene. Now remember, police are all through that hospital now because they get to the hospital at 10:12. That's going to be on your sheet. Remember, 5. So that's over an hour or so later. You got Officer Fish, Officer Pfeiffer, Detective Martin. You have all these officers who are now interviewing Najee, interviewing Blaise. And Najee knew it, and I guarantee you, Ms. Burks knew it, Ms. Franklin knew it, and Lauren Weber knew it. And we know they knew it because Officer Fish told you that Ms. Burks was on the phone when she was talking to Ms. Browning. And she said that they told them the detectives are coming that night. But Lauren Weber remembers the significant other of Mario, the one who asked her to go get drugs that day. The first person in there is Lauren Weber. And she said, don't get lost on it. She said, all I did, I didn't touch anything. I grabbed the keys, blew out a candle, and left. But Officer Reese told you that she said she removed belongings too. And that she looked all throughout it. You can't do both. One of them is not true. Either you went in and grabbed keys and just left, Or you went in there and grabbed belongings and looked all throughout it. And if you did that, why lie about it? Just say what it is. Unless you had something to hide. Or unless you went to get something. Then notwithstanding that, now you have detectives on the scene. And Officer Fish told you that she told Ms. Burks and Ms. Browning, this scene is on lock. Nobody in, nobody out. But the truth is, nobody should have had to tell you that. Because if he did it and you think he did it, you want to leave that scene just the way it is. Because he may have made a mistake. And I want those officers to be able to catch that mistake. I don't want to touch it. Jade doesn't need to go back there that night. She's in the hospital. We're going to lock this thing down because we're going to catch him. I know he would have made a mistake. They went in there and they removed evidence. And they manipulated evidence by moving it from here to here. Why would you do that? And they said, oh, well, the officer gave us permission. And then you remember Detective Martin getting on the stand? And then he said, oh, I may have given them permission. And Mr. Joyner said, well, didn't you send me an email yesterday saying that you didn't? What changed? Oh, well, this morning when I got here, things changed. Okay. Don't allow that to happen. That's not right. Because what detective will tell a woman and 3 young girls, y'all go do the investigating for me, let me know when you're done and what you come up with? That doesn't happen. That doesn't happen. And then you have the only other eyewitness, the only other person in that house. He should be just as important as Nigel.
All right, Ms. Hollins, you need to be wrapping up your argument.
And Detective Reese, yes, sir. Detective Reese said, I like to bring people in to talk. But I didn't bother to have Keontae came down. I just called him on the phone. And Keontae wouldn't tell you the truth about his theft conviction. And he told you, because he didn't talk to anybody there that night, even though he went there. Why not? He said they didn't have security. There it is right there. Why didn't he talk? I don't have a lot of time left, so I'm going to go through it quickly.
You don't have any time left.
May I have 5 minutes? Yes, sir.
You got a minute.
I've given you the investigation. That's the towel he took. I got 60 seconds. I'm going to do my best. That's the towel he took. That's where he got it from. If he was cleaning up, he would have fixed those towels. But he didn't. That's the surveillance video. That's that missing cup. It was sitting there the entire time. No one in, no one out. That's the V8 bottle. It wasn't in there. You see the lemonade, you don't see the V8. And on those other pictures, you don't see it either. So, that's the communication log. Cocaethylene is in the system. You're going to have the reports. It's there, and it was there in the vomit. And all of these doctors told you that. And the autopsy report at the end of the day, don't forget what I've shared with you. At the end of the day, even the medical examiner can't come to a conclusion. And with all these surrounding circumstances, how can you? Now, I told you that when you get back there, you're going to be tired and it's going to be long. And you promised me that you would not let anyone change your convictions of what you believe, no matter how long it takes. Because you said if they can't make a decision in the most important affairs of your life, that you wouldn't let them do it for Blaise. I thank you so much for for your patience, and for being here. And the Taylor family does as well. I won't get back up here and make another argument because we don't have the burden, they do. So when you get back there, you make the argument for me. Thank you.
All right, any rebuttal argument on behalf of the state?
Yes, Your Honor. Ms. Hollins went back and forth between whether or not Blaise Taylor even thought he was the father of this child. She said that Nigella Jackson said she wasn't sure. You heard the testimony. I submit to you that Nigella said she was sure, it's just he wasn't involved. And she was saying that at the hospital because he was telling the people at the hospital that he loved Jade more than her. And she was, that was not true. That's what she testified to about whether or not he was the father. She told all of the officers, he's just the father. He's not involved. But Ms. Hollins argued to you that he wasn't the father, but then she also wants you to consider a text message where Jade is telling her mom that he signed up for a diaper service. You can't have it both ways. Also, Blaise Taylor told people he was the father of her baby. He told Keontae, Nigella, the people at Vanderbilt. He told the police officers. Now, when he calls 911, he's with a friend. But when the police come, that is his girlfriend. He is absolutely committed. And the text messages with Xavier Winford absolutely were not submitted for any purpose of saying somehow Mr. Taylor was a bad person because he was seeing more than one woman. It was for that very purpose. He had someone that he loved, that he was telling, I love you. But also the rest of that thread is that something's happening, but everything's going to work out for them. But it's very much against what he told the police, that Jade Benning was his girlfriend. His interactions with her, it wasn't I love yous. She also wasn't going to admit he's the father of the child, but yet wants to say that they picked out the baby's name together. Well, Nigella Jackson testified about that, and she was very specific that that was a name that Jade suggested, and he agreed. He didn't disagree with it. But you also heard testimony that Jade's unborn baby girl's name is Ivy. She, just to clarify, I don't know where the Lauren Weber Mario connection came from. I submit to you that the evidence that you heard was that Mario texted Jade. Jade texted Danny. Danny wasn't in town. No one met up. Lauren Weber was not involved in that. Lauren Weber went to the apartment, and her testimony was that it seemed too clean. And she told the officers that. That was the first thing she said to them. She went in, and it was so weird to her that she took 2 pictures, and she walked the apartment. I submit whatever happened within the police department for officers to not go there that night and seize that scene, absolutely. That is a mistake. That should have happened, and it did not happen. But it doesn't change anything. Thank God for Jade's family and friends that they were not happy because nothing was happening, and it needed to happen. And they took care of it. There was nothing that was disturbed. Now, Mr. Taylor in the cleanup, he did not put the camera back. And they put the camera back where it would be, where it would face the door, not knowing if he could come back in because the police aren't there. Ms. Hollins also argued that somehow if he wanted to kill the baby, that he wouldn't be wanting updates from Jade's mom. Jade's mom's updating him because nobody knows yet about the cocaine. That first drug screen in the hospital, it was negative. Nobody knows what's happened. She referenced the cause of death with Dr. Carney. Not the cause of death, the manner of death with Dr. Carney. And she put the report up, and it very clearly states that there's a suspicion for homicide because it's possible that she ingested the cocaine without her knowledge. Someone gave it to her. But Dr. Carney's determination has nothing to do with yours. Your determination is reviewing all of the evidence to determine what proof beyond a reasonable doubt. If she determined it was a homicide, you could not consider her determination for your decision. That is for the death certificate. Ms. Holland's arguments to you about Blaise Taylor. We wish we had the surveillance video. Yes, it would be much better if we had the surveillance video, but not to exculpate him. It would show him going in and out. How long was he out there before he went back inside on 911? How many times did he go out there? It would show Jade Benning pulseless the way he saw her being carried out by the EMTs. There is nothing about that that undoes the proof in this case. She argued that a chef would know that there was something in a drink. Jade Benning absolutely said, I knew there was something in my drink because I tasted it. Those are the facts. Ms. Holland's entire argument is asking you to ignore the testimony that again was unimpeached by Nigella Jackson, that Jade Benning said all of these things. She said them to him. It's only the two of them in the apartment. He says it's only the two of them. He says Jade was talking to me. Her arguments to you are asking you to not only ignore everything that Jade Benning said, but it's to ignore that if for some reason it was true and Jade Benning ingested the cocaine herself to kill herself and her baby, and then called her best friend and said these things to Blaise Taylor, and Blaise Taylor never tells anyone what she said. He doesn't, when he sees Nigella, say, oh my God, what happened? She said these things. I didn't do anything. We have to figure out what's going on. That is absolutely not true. He didn't tell anyone what Jade said. And when Detective Smith asked him if Nigella would have any reason to make up these accusations, he didn't even say she was making it up. He said, I think she's just in shock, and I was the last one with Jade. There is no explanation because Jade Benning said these things. It is the proof and evidence in this case. Jade Benning named her murderer and the murderer of her baby, and she told you why. The state does not have to prove the why, but Jade Benning told you why. And I submit to you that the evidence in this case is proof beyond a reasonable doubt that Blaise Taylor is guilty of all 4 counts of the indictment. Thank you.
Members of the jury, count 1 and 2 of the indictment in this case charge the defendant Blaise Taylor with the offense of first-degree premeditated murder. This offense embraces the lesser included offenses of second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide. Counts 3 and 4 of the indictment in this case charge the defendant Blaise Taylor with the offense of first-degree murder during the commission of a felony. This offense embraces the lesser included offenses of second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide. The indictment of this case is a formal written accusation charging the defendant with these crimes. It is not evidence against the defendant and does not create any inference of guilt. To this indictment, the defendant has entered a plea of not guilty. The evidence and arguments in this case have been completed, and it's my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. At times during the trial, I've ruled upon the admissibility of evidence. You must not concern yourself with these rulings, neither by such rulings, these instructions, nor any other remarks which I have made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. As to any question to which an objection was sustained, you must not speculate as to what the answer might have been or as to the reason for the objection, and you must assume that the answer would be of no value to you in your deliberations. You must not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken out by the court. Such matters to be treated as though you had never known it. You must never speculate to be true any insinuation suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. Sometimes in the trial of a criminal case, when a defendant is charged with a crime or crimes, this crime or crimes include lesser included offenses. The law permits the jury to find the accused guilty of the lesser included offense, which is included in the crime charged in the indictment, whenever a course of conduct is consistent with the facts found by the jury from the evidence in the case and when the law is given in the instructions of the court. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in light of your own observations and experience in life. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The court will now instruct you as to the law applicable to all counts of the indictment. First, it will set forth the laws applicable to the crimes charged in the indictment. Finally, it will describe for you the deliberation process. Counts 1 and 2, first-degree premeditated murder. Any person who commits the first-degree premeditated murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Any alleged victim includes a human embryo or fetus at any stage of gestation in utero. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and that the defendant acted knowingly. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The definitions of intentionally and knowingly which apply to this offense have been previously explained to you in these instructions on page 6, and you should refer to those definitions as they apply to this instruction. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Counts 3 and 4, first-degree murder during the commission of a felony. Any person who commits first-degree murder during the commission of a felony is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, and 2, that the killing was committed in the perpetration of or the attempt to perpetrate an alleged first-degree premeditated murder. That is, that the killing was closely connected to the alleged first-degree premeditated murder and was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the alleged first-degree premeditated murder. For the defendant to have been found guilty of first-degree premeditated murder, the state would have had to prove beyond a reasonable doubt the essential elements of first-degree premeditated murder, which have been previously set out on page 5 of these instructions, and you should refer to those instructions as they apply to this offense. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged first-degree murder. The killing may precede, coincide with, or follow the first-degree premeditated murder and still be considered as occurring in the perpetration of the first-degree murder, so long as there is a connection in time, place, and continuity of action. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Any alleged victim includes a human embryo or fetus at any stage of gestation in utero. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, as to count 1. As to count 3, Jade Benning, and as to count 4, the unborn female child of Jade Benning, and 2, that the defendant acted knowingly. Knowingly means that a person acts knowingly with respect to the conduct or circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established that if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The definitions of intentionally and knowingly which apply to this offense have been previously explained to you in these instructions on page 6, and you should refer to those definitions as they apply to this instruction. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, and 2, that the defendant acted recklessly. The definition of recklessly has been previously defined to you in these instructions, and you should refer to that definition as it applies to this instruction. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, and 2, that the defendant acted with criminal negligence. The definition of criminal negligence has been previously defined to you in these instructions, and you should refer to that definition as it applies to this instruction. When you begin your deliberations on the indictment, you must first deliberate on the indicted or charged offense. If you find the defendant guilty of the indicted offense, you may stop your deliberations as to the remaining charges within that count of the indictment. If you find the defendant not guilty of the indicted offense, or you have a reasonable doubt, then you must find the defendant not guilty of the indicted offense and next consider the lesser included offenses as set out in your verdict form. You must first deliberate on the greater offense and reach a verdict as to the greater offense before you move on to the next lesser included offense. If you reach a verdict as to the guilt of the defendant as to a greater offense, you may stop your deliberations as to that specific count. If you find from the proof beyond a reasonable doubt that the defendant is guilty of murder in the first degree as to counts 1, 2, 3, or 4, then it shall be your duty after a separate sentencing hearing to determine whether the defendant will be sentenced to life imprisonment without the possibility of parole or life in prison, but you will not consider punishment for this offense at this time. I noticed that some of the jurors appear to be making notes during the trial of this case. Please bear in mind that these are your notes and for your use alone. The taking of notes is simply an aid to memory, and the jury must understand that they are to recall the testimony and to use the notes only as an aid to memory. And any juror who takes notes will use those notes only for that juror's assistance in that regard and not as an authoritative thing to show others. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. The court charges you that if you are satisfied from the whole proof in the case beyond a reasonable doubt that the defendant, Blaise Taylor, committed the crime charged against him, and you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the crime charged, then it would be your duty to convict him. On the other hand, if you are not satisfied with the identity from the proof, or you have a reasonable doubt as to whether he has been identified from the whole body of proof in this case, then you should return a verdict of not guilty. During the trial, you heard expert testimony of Dr. Michael Olashoga and Dr. Kelly Larkin, who is described to us as an expert in the field of emergency room medicine, Detective Tom Miller, who is described to us as an expert of the field of digital forensics, Dr. Aaron Carney, who is described to us as an expert in the field of forensic pathology, Dr. Carrie Midthen, who is described to us as an expert in the field of forensic toxicology, Eric Devlin, who is described to us as an expert in the field of digital forensics, Nicole Dowell, who is described to us as an expert in the field of forensic science drug identification, Dr. Alex Kroltulski, who is described to us as an expert in the field of forensic pathology, Dr. Melissa Giguere, who was described to us as an expert in the field of forensic toxicology, and Dr. Janice Lindsay, who was described to us as an expert in the field of forensic toxicology. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness. It is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Direct evidence is defined as evidence which proves the existence of the fact in issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact in issue, but from which that fact may be logically inferred. It is evidence that proves one or more facts from which you find or infer the existence of some other fact or facts. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. An inference is a reasoned, logical decision to find that a disputed fact exists on the basis of another fact. You should consider all the evidence that is presented in this trial direct and circumstantial. The law makes no distinction between the weight that you should give either direct or circumstantial evidence. It is for you to decide how much weight to give any evidence. You are the exclusive judges of the credibility of the witnesses and the weight to be given their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can without hastily or rashly concluding that any witness has sworn falsely. For the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any, are shown, and all the evidence in the case tending to corroborate or to contradict him or her. A witness may be impeached by proving that he or she has made material statements out of court which are at variance with his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such statements. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved in the trial. If from the evidence presented you find that a witness has been convicted of a prior crime, you can consider such only for the purpose of its effect, if any, on his credibility as a witness. The defendant has not taken the stand to testify as a witness, but you should place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Tape recordings were allowed in evidence, and you were provided with a document purporting to be a transcript of the audio tape. This document was provided to you to assist in your listening to the audio. If from your listening to the tape you find discrepancies or inaccuracies between the transcript and the tape itself, you should rely upon your understanding of the tape and disregard those portions of the transcript you find to be inaccurate. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Davidson County, and that it was committed before the finding and return of the indictment in this case. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement. if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. In that event, your foreperson will report that you found the defendant guilty and name the offense according to your previous instructions. On the other hand, if you find that the state has not proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt, then you must find the defendant not guilty. In that event, your foreperson will report that you find the defendant not guilty. You will be provided with a form for all possible verdicts in this case. For each count, the jury will check the appropriate verdict on the form, and your foreperson will sign the verdict form. The verdict form which you'll receive reads as follows. Verdict form. We, the jury, find the defendant Blaise Taylor, count 1, first-degree premeditated murder, and count 1 and 2, the verdict forms is the same. Choose 1. Guilty of first-degree premeditated murder, or guilty of second-degree murder, or guilty of voluntary manslaughter, or guilty of reckless homicide, or guilty of criminally negligent homicide, or not guilty. Count 3 and 4, the verdict forms are the same and read as follows. Count 3 and 4, first-degree felony murder during the commission of a felony. Choose 1. Guilty of first-degree felony murder during the commission of a felony, or guilty of second-degree murder, or guilty of voluntary manslaughter, or guilty of reckless homicide, or guilty of criminally negligent homicide, or not guilty. There's a signature line for the foreperson and a line for the date. When you retire to the jury room, you will first select one of your members as a foreperson who will preside over your deliberations. When you have reached a verdict, you will return to this courtroom and your foreperson will announce it. You must not imagine that the court has any opinion in regard to the facts. It is your duty to find them, and have attempted to read this charge so as to define to you the law without indicating any opinion about the facts whatsoever. Members of the jury, the indictment in this case is herewith handed to you together with the charge and the exhibits in this case. You may now retire and consider your verdict. And let me swear in the court officer. Do you solemnly swear or affirm that you will keep this jury committed to your charge, keep them separate and apart from all citizens, allow no one to communicate with them or communicate with them yourselves on the subject of the trial?
I do.
All right, let the lawyer step up just a moment. 12 regular jurors, if our 4 alternates, I'll speak to you in just a moment, can stand right there against the wall there. The other 12 of you, if you'll step down the hall, we'll get these items to you. All right, the alternates, obviously the court never knows whether we'll need someone to substitute into the deliberation process or not. Would have expected a week ago, Monday last week, that we probably would, but we didn't. So I appreciate your service. You'll be discharged from this case. We'll shred your notes for you, and you can step out with the court officer. All right, we'll be in recess.
Court to the recess.
All right, the court's staff's been made aware that the jury's arrived at a verdict, so we'll let them step down and announce it. Just out of respect to the jury, just keep your reactions, if any, to yourself, and we'll deal with it. All righty? All right, you can have a seat. All right, ladies and gentlemen of the jury, the court just, and I say this just to reference to you by numbers. We start down at the far right and run down this way, 1 through 6, upper right, 7 through 12. So, Miss Juror number 7, you are the foreperson? And the jury's arrived at a unanimous verdict? All right, if you would, please, ma'am, stand and announce that verdict on behalf of the jury.
We, the jury, find the defendant Blaise Taylor for count 1, guilty of second-degree murder. For count 2, guilty of first-degree premeditated murder. For count 3, guilty of first-degree felony murder during the commission of a felony. For count 4, guilty of first-degree felony murder during the commission of a felony.
All right, if you'll turn that document in, please, ma'am. All right, ladies and gentlemen of the jury, you can back up just a second. Ladies and gentlemen of the jury, you've heard your foreperson, juror number 7, announce your verdict in this particular case, that you found Mr. Taylor guilty of, in count 1, second-degree murder, in count 2, first-degree premeditated murder, in counts 3 and 4, felony murder during the commission of a first-degree murder. I'll ask you if that is your individual verdict. If it is, you would indicate it is. If it's not, you would indicate it's not. Juror number 1, is that your individual verdict?
Yes.
Juror number 2, is that your verdict?
Yes.
Juror number 3, is that your verdict?
Yes.
Juror number 4, is that your verdict?
Yes.
Juror number 5, is that your verdict?
Yes.
Juror number 6, is that your verdict?
Yes.
Juror number 7, the 4-person, is that your verdict?
Yes.
Juror number 8, is that your verdict?
Yes.
Juror number 9, is that your individual verdict?
Yes.
Juror number 10, is that your verdict?
Yes, sir.
Juror number 11, is that your verdict?
Yes.
Juror number 12, is that your verdict?
Yes.
Okay. All right, thank you very much. As you know, we'll need to discuss with the attorneys further issues in this case. Don't discuss the case any further. We'll get back with you here shortly. You can step down the hallway with the court officer. All right, Mr. Taylor, you've heard the verdict of the jury in count 1. They found you guilty of second-degree murder. That verdict, as well as the other counts, guilty in count 2 of first-degree murder, counts 3 and 4, first-degree felony murder, will become the judgment of the court. In terms of counts 2, 3, and 4, will be the need for further sentencing hearing. Does the state contemplate introducing victim impact statement?
Yes, Your Honor, upon the court finding that by the jury's verdict that we would be entitled to do that.
Okay. We'll take just probably a 15-minute break and let everyone settle down in terms of the initial verdict. Come back and hear that proposed testimony under State versus Nesbitt, and then see Mr. Grant, Ms. Hollins, Mr. Joyner, what mitigating factors you want to submit and find that's necessary to submit to the jury. So,
Please, the court, the state's position is that Nesbitt only applies in death penalty cases.
what
As far
what I'm
as
talking
doing-
about, as far as victim impact, 403 analysis.
Under Nesbitt, if it's life without parole, there is no analysis.
So you
That
can,
is, there's no dry run unless it is a death penalty
you
case.
can just have whatever that may be overly prejudicial.
No, it will be victim impact under pain.
Okay. And does Mr. Brand, Ms. Hollins, you have prepared proposed mitigating circumstances?
Yes, Your Honor, I think there are mitigating circumstances, mitigating factors we would argue to the jury.
Okay, all right, if you'll get those,
I think we need a minute probably.
okay, like I said, we'll take a short break, but let me ask the state this. There are cases with obviously with the finding in count 1, that wouldn't be considered by the jury, but there's also, I think it's Hargis versus State, that does apply to any felony murders, that your notice that you submitted, the felony murder portion, I think it's your number 2, wouldn't apply in counts 3 and 4.
Disagree, Your Honor, because it is Middlebrooks. It is not a Middlebrooks situation. It is within the legislation that amended the statute post Middlebrooks. So that is something the state submits the jury can consider in a felony murder sentencing,
That an aggravating factor is the felony murder.
which is based upon that aggravating circumstance, which is above and beyond just the definition of felony murder.
What do you mean by that?
Well, that the jury would have to find the aggravating circumstance that, again, that it is not a Middlebrooks situation, so that the state's position is the jury can consider that as an aggravating circumstance. That was the whole issue in Middlebrooks.
But there's some that would only apply to certain counts.
Yes, Your Honor, the age of the victim, certainly.
Right. All right, we'll take 15 minutes and then come back and hear from the defense in terms of mitigation.
Yes, Your Honor, the state would like to be heard or
Oh,
see
sure.
that. And
Yeah, let them.
we have an argument about.
Taylor, and by law, Mr. Taylor, your bond has to be revoked, so if you'll step into the back and talk with your attorney.
Welcome to 15 minutes.
Yes.
I was just saying, when the defendant was out, that matter.
Okay. Well, yeah, you can bring him up. What is it?
Your Honor, on the notice that the state filed to seek imprisonment for life without the possibility of parole, based upon the jury's verdict in count 1, the state would move to basically strike our number 3 and what would be in the code section number 16, because that requires an intentional.
As to
The murder was committed against a pregnant woman.
Right.
And the defendant intentionally killed the victim. The jury's verdict of a knowing killing, I think, removes that as an aggravated
from what would be, if it had been instructed at all, in count 3. Right.
Yes, sir.
Okay.
Yes, sir.
All right, so that wouldn't be, all right, now, any submission, Mr. Brand, Ms. Harris, on the mitigating circumstances?
Yes, Your Honor. As far as mitigating circumstances, and I've discussed this with Mr. Moore, we would submit that the mitigating circumstances in section J1, that the defendant had no significant criminal history, would be appropriate in this case. My understanding is there's no objection to that.
Okay.
That's correct, Your Honor.
And then, I apologize, I don't know which number this is, but the catch-all provision that
Number
any other...
10.
Yes, number 10, any other circumstance essentially fairly raised by the proof in this case.
Does the state care to be heard on that?
Judge, submit under the law that has to be specific as to what that is, like a list of that the defendant graduated top of his class and those sorts of things.
Sure,
not just a catch-all.
Right, and so to specify, we would intend to put on proof related to Mr. Taylor's education, his high performance in school, his high performance in athletics.
You would?
We are going to.
Okay.
Yes, we are going to put on that proof today at today's
Okay.
hearing. His involvement in nonprofits, so community involvement, other essentially positive personal traits and background related to Mr. Taylor that would support mitigation.
Okay. All right, I guess we can discuss the language of the court would place in there once we hear the proof. Anything else before the jury's brought down?
No, Your Honor.
You give opening statements
A
and,
brief, yes, Your Honor.
okay.
And we would as well, the state.
Okay. And does the state, just again for court's edification, know how many witnesses you may be calling?
3.
Okay. All right, let the jury step down. But General Moore, the states, are you in agreement that the jury would be instructed in terms, well, I can ask this later. It dealt with victim impact statement not being an aggravated circumstance.
Certainly.
Yeah.
And the jury can only consider that after they have found the existence of at least one aggravating circumstance.
And just before we get into an issue, the victim impact statements are not going to include any statement of what they want.
No,
to happen.
no, we've discussed that.
Okay. Or you can have a seat. All right, members of the jury, when we get to this portion of this particular trial, the law allows for the attorneys to give to you opening statements, then present proof, and I'll explain all this in the jury instructions. The parties are allowed to introduce appropriate, relevant proof to the issues for your determination in terms of the penalty that the state's seeking of life without parole, or whether it should be a life sentence imposed on the counts 2, 3, and 4 that you've rendered the verdict on. Right. Does the state care to make an opening statement?
Yes, Your Honor. Just briefly. Members of the jury, because of your verdict, we are now going into the second phase of this trial. And what the state will present is based upon, like it seems long ago that I read the indictment. In this part of the proceeding, the state relies upon aggravating circumstances that are named. And there are 2 of those presented for your consideration. Number 1, the murder was committed against a person less than 12 years of age, and the defendant was 18 years of age or older. So referred to Ivy. Number 2, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit, or was fleeing after having a substantial role in committing or attempting to commit any first-degree murder. Again, based upon your verdict. the existence of those circumstances have been found beyond a reasonable doubt by your verdict. That allows, at this point in the proceedings, for the state to present what under the law is called victim impact testimony, to give you a view into what Jade and Ivy's death, the effect it has had on her family, her extended family, and not going into really anything else. It's limited to that. Victim impact. And we'll be calling 3 witnesses. Jade's aunt, Brandi Moran, and who would have been Ivy's great aunt, Andrea Browning, who you have heard for before, and Jade's mother and Ivy's grandmother, Bridget Burks. At the conclusion of that testimony, and whatever the defendant chooses to present anything, this is what this is proceeding, that is submitted to your discretion. The judge will tell you the law, and once we conclude the proof, there'll be opening argument of the state. Perhaps the defense would have a chance, or they will have a chance to make an argument, and the state would close. Again, because we have the burden of proof without a criminal trial. But that is the process, and that is what you will hear in this part of the proceedings, to allow you to, in your discretion, determine what the punishment should be for the 3 first-degree murder cases. Thank you. Thank you, Your Honor.
All right, any opening statement?
Thank you. This case is and always has been tragic. Nothing that anybody's going to say in this relatively short portion of the trial is going to change that. And the thing we are going to ask you to remember is, even if you find there's aggravating circumstances, and really the aggravating circumstances the state is going to ask you to find are based on your conviction. Mr. Taylor's been convicted, there's no question. It doesn't require you to give him the harshest penalty ever. He's going to prison no matter what. The best outcome today is the rest of his life in prison, 60 years in prison, with maybe in 51 years, he goes up for parole. He's 30 years now. At 80, he goes up for parole. That's the best outcome for today. You don't have to give him life without the possibility of parole. You can give him the opportunity to try for rehabilitation. You can give him the opportunity to work hard in prison. He's not going anywhere. This is a tragic case, but it doesn't have to be the worst of the worst outcome. Thank you.
All right, who's the state wanting to call?
Your Honor, the state's first witness would be Ms. Brandi Moran, and as part of the proof in this portion of the proceedings, the state would ask the jury to incorporate all of the proof that has been presented.
Okay, I mean, the law allows that. All right, let her step up. Raise your right hand.
Do you swear the testimony you're about to give to be the truth, so help you God? Yes.
Ma'am, could you please state your name and spell your first and last name for the court reporter?
Brandi Moran, BRANDIMORAN.
You heard me say a few minutes ago that you were Jade's aunt and would have been Ivy's great aunt. Is that correct?
That's correct.
And just so we're clear about the relationship, explain the family dynamics to us.
Well, she was my niece. But I was there with my sister the day she was born. I was in the delivery room when she was born. And for lack of not having children of my own for many years, she was like a daughter to me. My sister and I are very close, and so she was more than just a niece to me, and the same with my husband.
And just to be totally clear, who is your sister?
My sister is Bridget Burks.
And so you have known or knew Jade from the moment she was born. Is
The
that
first
correct?
breath she took, I saw.
And throughout her life, did you remain in her life?
She, like I said, was like another child, or like my only child for a long time. In fact, she was 13 when I finally had my child, and she was less than thrilled that I was bringing someone into the world to take her place, which he never did. But we took her, my husband and I took her to Disney World for the first time. I took her on her first trip to New York. She loved to travel. She was full of adventure. We traveled Europe together. We were in each other's lives when she went to culinary school. She lived with my husband and I. So we were very, very close.
And where were you when you learned about the February 25th, 2023 incident?
I was at my home in Northwest Arkansas, and I was actually folding laundry. My sister called and said something's happened with Jade. I don't know what's going on, but we're heading to Nashville. And I immediately we talked for a little bit. She was in the car, and in the meantime, my husband was in the background. Northwest Arkansas doesn't have a ton of direct flights, and it's a good 10 or 11 hours from here. So he was getting flights for me, the earliest that we could get in Kansas City. And we actually drove all night so I could catch a first 6 a.m. flight out of Kansas City to get to the hospital.
Did you know before arriving at the hospital that Jade was expecting?
Oh, yes. I learned that Jade was expecting on November 9th, 2022, because it was my son's 10th birthday. And she had actually traveled to Arizona. I was in Scottsdale for work, and my work was wrapping up, and I was flying out my son, and Jade flew out, and my best friend, so we could celebrate my son's 10th birthday together. And so she arrived at the hotel, and I was extremely excited that my event was over with, and was ready to, relax, and, wanted to have a cocktail with her, and she kept refusing. And so she finally had to tell me without everybody being there, but she had gotten me a little bag that said only the greatest aunts become great aunts, and it had a picture of the ultrasound inside. So from then on, if you look at our text, every single communication after that was about this baby.
And so would it be fair to say you were looking forward to being a great aunt?
Oh, yes. I had already asked off work I didn't have to ask off work, I work remotely. I'd already informed my boss that from middle of June through when my son had to go back to school, I would be working remote in Nashville, helping her learn how to become a mom.
The jury has heard that she was removed from life support, she and Ivy, on her birthday. Is that correct?
That's correct.
What was that like for you, yourself, going through that time?
It was probably, I thought, when my mother passed away a few years prior to that, that was the hardest thing I was ever going to go through. But nothing prepares you for what you see as your family's future going away. And although she wasn't physically my daughter, it was like losing a child. And not in a way that was fair, and especially at a time when my very last text to her was, "I'll see you on your birthday to celebrate." And that's what I was expecting that weekend before. I didn't expect to be driving to Nashville to experience what we experienced.
From the moment you heard, got to Nashville, saw what was happening, has there been a day that's gone by that you haven't had this on your mind?
No, it's completely changed. We have a small family to begin with, and it's taken away I won't say it's taken away happiness, and I've done a lot with therapy and grief, and it's never going to go away, but there's never going to be pure joy in the celebrations that we have, because there's always going to be one of the big pieces of our joy missing. So there's...
And with respect to the family, your sister, Browning, people we have heard from, have you seen how this has affected them?
Oh, it's everything. It's how we operate in life now. It's even how I allow my son to do things, because we are a normal family. It's just, this isn't anything you ever think you're going to talk about. When I say we were boring people, and we liked it that way, and just, you can't let go of the fact that this type of thing now, really happens to other people. It happens to you too, and it can happen to you. And so it impacts every decision, every thought. There's just, across the board, with my sister, with, our father, with my husband, my son was 10 at the time, and just trying to explain to him why somebody that was, just like a sibling to him is no longer here.
I was going to ask about that, because Jade and your son would be cousins.
They were cousins, but they were
closer than that.
They fought like brothers and sisters, and she was 13 when he was born, and then she turned into his babysitter, and then, she hit adulthood, and he had a little bit of a problem with her being an adult and not just his cousin Jade. So they fought like brothers and sisters, and there's just, it's really hard for me, like I said, because we have a small family, and my husband and I had our son late in life, and we don't have a lot of other relatives, and she was his only cousin, and he's not going to have her now later in life the way I've had my sister. Like, I relied on, and she watched out for him. She could put him in his place like no other, and just, it kills me that I know that he's not going to have that anymore.
And have you seen that actually affect your son?
Oh, definitely. Our entire family has gone through therapy. He had a lot of problems right when everything happened in school, just with behaviors. And it's impacted every single day since it happened.
Prior to this, was your sister, family unit, happy?
Oh, yeah, definitely. We were, my husband and her husband are good friends. She and I are best friends, and his children, we all were just beyond just a happy, like I said, happy but boring, normal family. And there's just, I think somebody mentioned Jade's light, and that light's gone, and there's a dimness over our entire family that I don't ever see us getting back.
Can you describe, put in words, what you have seen this do to your sister, to Jade's mother, Ivy's grandmother?
It's just destroyed her. When she talked about Jade being her life, she was her life. They talked every day. And aside from the fear and the hurt I know she has, I've lived with the fear of is she going to be able to get mad at us? And thinking about my sister not being here because she can't live without her daughter has been probably one of the hardest things that I've sat and just prayed and hoped that she is strong enough and will be strong enough, because I can't imagine. I can't look at my own child every Mother's Day and feel guilty that he's still here, and my sister doesn't have her little girl anymore.
Thank you, Ms. Moran. No further questions.
Hang on just a moment. Question?
No question.
All right, thank you. You can have a seat. Who's the next witness?
Ms. Browning.
Do you swear the testimony you're about to give to be the truth, so help you God? Yes, I do.
Ms. Browning, could you please state and spell your name for the record?
Yes, it's Andrea Browning, Anderea, Browning.
Ms. Browning, what was your relationship to Jade?
She was my bonus daughter.
When did you and Jade's dad get married?
2009.
When did you first meet Jade?
She was about 7 years old, which is how old my daughter is now, our other daughter, Ava.
And can you walk us through Jade's early life?
Yeah, she was a little spitfire. The first time I met her, I'll never forget, because the light everybody keeps talking about, it's so obvious. And I was just, this girl was so full of life and so full of confidence. She always had a smile on her face, and she was always ready for anything. And she adored her dad and her family. She just, you could see it all over her face, and her body, her whole body lit up.
And Ms. Browning, do you have another daughter?
She has Ava.
How old is Ava?
Ava's 7 now. She was 3 at the time.
And can you describe Ava and Jade's relationship?
Yeah, that's tough because, like I said, Ava has Down syndrome, and so she's developmentally delayed, and she didn't know Jade because Jade was in Arkansas when Ava was born, and it was also during COVID, and we were taking lots of precautions about who we were exposing her to. And she finally met Jade in, I believe it was 2021, and they looked into each other's eyes and knew that they were sisters. There was a connection immediately. Like, it was really eerie, but also amazing at the same time. But having her here was so great for Ava because she got to know her last year. And also the toughest part about it was that. That's it. That's all Ava gets of her, was just that 1 year when she was 3 years old.
And what impact have you seen on Ava's life since losing Jade?
It's tough to tell her because she doesn't understand a whole lot about it, especially because she was so young at the time. But she's really into pictures, and she's always pointing Sissy out in pictures. And she asks about Sissy. She uses an AAC for communication. She just randomly hits Sissy on her words all the time. And it's got a little picture of Jade. And Sissy's always with you, is all we can tell her, and just keep explaining to her how great and wonderful her sister is and how much she loved her. And, one of the toughest things I'll have to carry with that is that the Instagram post that Jade made that said, being in Nashville, one of the best things about being in Nashville is getting to watch my sister grow. And they will know her.
And can you tell us about finding out Jade was pregnant and how excited the family was?
They were so excited. I was initially shocked, and she could see that, and I think it was a short conversation, but we were automatically super supportive of her and super ready to do anything and everything, take her shopping, help her with decorating, help her with anything she needed help with. I mean, I had just become a mom myself not that long ago. We talked a lot just about, whatever you need, we've got you. And she didn't ask for much. She had a hold on it. She knew she could do it. She's got all the confidence in the world.
And the jury has heard a lot about Jade's support system and how many people showed up to Vanderbilt and how many people took action that night. Can you describe for the jury Jade's support system, how many people she has here today, and what it's done to her friends?
I can't even begin to describe it because, like I said, she had only been here a year, and she was surrounded by people that were local. Like at the end, I mean, obviously everyone from Arkansas came down, but the amount of people that came there that were not from Arkansas that were there because she made an immediate impact on them, and they loved her so much, and they knew that this was going to be a huge loss to everybody.
And can you walk us through that night of February 25th and how you found out and how Jade's dad found out?
Yeah, I was actually asleep. I had a young child at the time. I had put her down a couple hours before, and I knew she was going to be up early, so I was sound asleep. And once I woke up, I saw the missed calls, and I was in such shock. I honestly don't remember a lot of who called when, where, how. And I know Bridget had several missed calls from her as well as Dennis. And as soon as I talked to Dennis and got to Vanderbilt somehow on my own, that drive was awful. I could barely even operate my legs because I knew there shouldn't be anything wrong with her.
And Jade was working at your brother's restaurant back in early 2023.
Right.
Can you describe the impact that her and Ivy's death has had on your brother's staff, your brother, just the restaurant as a whole?
Yeah. It was devastating. It's been really hard to watch my brother because he hired her. I mean, he didn't even hire her. He recommended her to the head chef, and it was a no-brainer for her to hire Jade. He just got her the interview. But everyone at that restaurant, and that's the biggest thing is they knew Jade was not doing anything she shouldn't be doing. They were always telling me that.
Yeah,
how great she was taking care of
Maybe a
all
jury
the
approach.
things.
I'm sorry.
Okay. All right, what's your next question?
It greatly devastated them. I can just leave it at that.
And Ms. Browning, is Jade's dad Dennis Browning?
Yes.
And can you walk us through the impact that Jade and Ivy's death has had on you and Dennis?
It's just been devastating, just knowing that Jade is only sister, and we know that she was always going to be around for her when we weren't, and it's ripped us apart. It's brought us closer together, but it's changed everything. We are very much more protective of Ava now, having experienced what we experienced, and I know that it's just changed everything forever for us.
Those are all my questions.
Any questions?
No question.
All right, thank you. All right, who's the next witness?
Ms. Bridget Burks. testimony you're about to give to be the truth, so help you God. Could you please state and spell your name for the record?
Bridget Burks, Bridget, Benning, Burks.
And Ms. Burks, who was Jade Benning to you?
My baby girl.
And was Jade your only child?
Yes.
How can you describe Jade growing up and her light?
As soon as she walked in the room, you knew, because she was so full of life. She's known for being very loud. She got in trouble several times for being loud. So you knew her presence, her laugh.
And Ms. Burks, does Jade have a stepfather?
She does.
Okay, and what's his name?
Lynn Burks.
And when did Lynn Burks come into Jade's life?
She was 6.
And can you walk us through the impact that Jade's passing and Ivy's passing has had on you and Lynn?
We also have 2 boys, and so it just makes it harder, makes us worry more about our other 2 boys. That was his baby girl. You couldn't tell him any different. And it's just a boy that will always be there.
Is your day-to-day life different without Jade?
Most of the time. People ask, are you okay? And I always say yes. But behind closed doors, I'm not.
And did you and Jade talk almost, if not every single day?
Yes.
And Ivy would have been your first grandchild?
Yeah.
Can you walk us through the impact of losing Ivy?
Well, I'm the youngest of all my friends, and I'm the only one that didn't have a grandchild. So I was excited to be able to say I'm a grandma now. I'll never get that opportunity because it was taken from me.
And is there a day that goes by that you don't think about Jade and Ivy?
No, every day.
These are all my questions.
Any questions?
No question.
Thank you. Have a seat. Any other witnesses from the state?
No, Your Honor.
Any proof on behalf of Mr. Taylor?
Yes, Your Honor. Very, very briefly, I would actually call Detective Adam Reese, who I believe is in the court.
Okay.
You swear the testimony you're about to give to be the truth, so help you God.
Yes.
Detective Reese, as part of your investigation in this case, did you pull criminal history reports on Mr. Blaise Taylor?
Yes.
Do those include NCIC sort of nationwide background checks?
Yes.
In your investigation of criminal history on Mr. Taylor, did you find any prior criminal history?
No, I did not.
Thank you, that's it.
Any question?
No.
Okay. All right, who's the next witness?
Your Honor, we would call Evie Taylor.
Okay.
Do you swear that the testimony you're about to give to be the truth, so help you God?
It's Dr. Taylor, right?
Yes.
Dr. Taylor, can you please state your full name and spell it for me?
It's Evelyn Taylor, EVELYN-TAYLOR.
And Dr. Taylor, what is your relationship to Blaise Taylor?
He's my son.
And how many children do you have, Dr. Taylor?
2.
And is Blaise your older child or younger child?
He's my oldest.
And how old are your 2 children?
30 and 28.
So, Mr. Taylor is how old?
He's 30.
Where do you live, Dr. Taylor?
I live in Texas.
Can you tell us a little bit about who Blaise Taylor is?
Yes. He's the best son I could ever ask for. He's a loving son, a loving brother, a loving grandson, a loving nephew, a loving friend. He's never given me any problems. All throughout school, he was an A student. He was always the teacher's pet. In fact, his kindergarten teacher still keeps up with them to this day. He liked to help other children with their schoolwork because it just naturally came so quick to him. And the teachers would always comment about that. He loves sports. He wanted to follow in his father's footsteps, and so he played sports. Every time we moved, he made a lot of friends. He was team captain and leadership. He was a team leader. A lot of the parents would come to me and tell me that how much respect they had for him. He was a good student in the classroom and in sports, and he was the type of boy that they wanted their children to hang around because he was never getting in any kind of trouble and was very respectful.
Where did this? I'm gonna interject for a minute. Where did Mr. Taylor grow up?
We lived all over. He was born in Texas, but because of my husband's profession, we move every few years. So we lived in Texas. From there, we went to New Mexico, and then Louisiana, and then Tennessee, then Oklahoma, and then Alabama, and then Arkansas.
And is it fair to say sports are kind of a big deal for your family?
Yes.
So you mentioned he was very involved in sports. What sports specifically was Mr. Taylor involved in?
Well, his favorite sport was football.
And that's real big in your family.
Yes.
Right? When did he start playing football?
When he was 5 years old.
And how long did he play?
He played through college, and then he got an invite to try out for the New Orleans Saints upon graduation or after his senior year.
And he ended up not pursuing it professionally?
He didn't make the team, the Saints.
How did he, let's start with high school. How did he perform in football in high school?
He was a team captain in high school, one of the leaders on the team. He actually graduated early. He graduated a semester early so he can go to college early.
And you mentioned a little bit about his grades while he was team captain and playing football. How were his grades in high school?
All A's.
And then where did he end up going to college?
He went to Arkansas State University.
And I think we heard a little bit about that during the trial. Did he play football in college also?
Yes, he played football in college, and he actually graduated with his bachelor's and his master's degree in business in 2.5 years. He was the first college football player to ever do that. And while he was there, he started a nonprofit, the Power 1 or 2. He's very passionate about helping children in underserved areas and communities. And so while in college, him and his sister co-founded that nonprofit. And they just did a lot of community events for those children, mentored them. He was a big brother. He volunteered at the alternative school. And his senior year, I think he went like 3 times a week.
Does that nonprofit still exist?
The nonprofit still exists. They've actually given almost like over $90,000 in scholarships. They help each year. They do school supply drives for kids in underserved areas. They do Thanksgiving baskets and adopt a kid for Christmas for children that don't have resources to get presents for Christmas. Pretty much whatever the needs are wherever we live in the community. They just try to serve those children and just meet their needs.
And you said Mr. Taylor's sister was involved in that as well?
Yes. So if you talk to his sister Star, she'll say that he's her role model. She followed behind in his footsteps, and she's an A student as well. And if you ask her why does she make A's, she'll say because Blaise did. Why do you play basketball? Because Blaise did. From the time she was little, he would help her put her shoes on the right feet. When I was her coach, she would be looking at him. And even though he was only in junior high, she valued his opinion and wanted to hear what he was saying, what she can do better, how she can improve. Whether it was in the classroom, whether it was with sports, whether it was trivia things or whatever, whenever she needed advice, she would say that she would go to her brother.
And is Blaise's sister here? Has she been here?
She is. She has been.
Is your family close?
We're a very close-knit family. When we move a lot, we know we have each other, and then every time we move, we make several moves, but we always find like adopted families wherever we are. Usually it's through sports. Kids under sports teams, and then they become a part of our family.
I know that this process has been very hard. Does Mr. Taylor have support still from your family?
Oh yes, he has support from our family. We have family members here. It's just hard because we're not from Tennessee. And we've had lots of different moves, so people that we're close to are in various states across the U.S.
So when Mr. Taylor started working for the Titans, which we heard a bit about, he was in Tennessee and you were still in Texas?
No, we were in North Carolina at that time.
You were in North Carolina. Okay. Did you have an opportunity, did you keep up with sort of how he was doing in work?
In work, yes. We talk regularly, and football's a big part of our family. That's what his dad does, so we have lots of conversations about work.
What's your impression of Blaise's work ethic?
Oh, he has a really good work ethic. If you ask anybody that knows him, that's one of the characteristics they'll say. He's a hard worker. He's always on time. He'll be one of the first ones there. He's going to make sure that he gets the job done. He has a really good work ethic in everything he does, whether it was his schoolwork, an actual job where he's getting paid, whether it's the non-service, he always goes above and beyond.
Okay. How about, are there any other, we talked a little bit about the nonprofit, are there any other kinds of community involvement or examples that you can think about from Blaise's life, either recently or longer ago, that you can tell the jury about?
Well, he has a servant's heart, so he does a lot of community service. Usually wherever we live, like with his dad, the football teams usually do community service, so he would be involved in various things that they do. I know one thing, like when he was in high school, where he was actually old enough to make a decision to do those things, he was really involved with the Miracle League. And so that's something he did throughout high school with big brother type programs, mentoring younger children. He would do that. And then when he was in college, he just did a lot of community service, like I was telling you about, like for his nonprofit. But it was primarily through being a big brother and volunteering at the alternative school. So being a mentor, he had a little brother that was assigned to him, and he would bring him to football practice and let him watch. He would go to school and help him with his homework and do things of that nature. And then when he volunteered, I believe it was the 3rd grade classroom at the alternative school, he would just encourage them to do their schoolwork, to respect their teacher. And if they made their points for the week, he would come and he'd bring teammates, and then they would play dodgeball and things like that. And if they had a good week and a good report, he would let them come with him to, or he'd get tickets for them to come to the football game. And he was really involved with the community baskets, and we would do community Thanksgiving dinners. I think one of the things that I'm most proud of Blaise for was one time when he was in college, we were in church, and they were doing baptisms. And I didn't know this because, he didn't tell me this. I'm just watching the baptism, and all the people come up and give testimonies, and it was a young college girl. And she said, I just want to thank Blaise because he really shared about the Lord to me. And he's really instrumental in my relationship with the Lord and my baptism. And all the accolades that he had, like in the classroom or on the field, they were nothing compared to what I feel like he did for this young lady that said that she's a friend that just went to the university. And just the fact that he was instrumental in her being baptized, it's those types of things that make me really proud of Blaise.
Dr. Taylor, one Thank you, Dr. Taylor. I think that's all. Well, let me ask this. Is there anything else you think you want to share with the jury that I haven't asked you about?
Your Honor, I would object to being that open-ended.
Okay. And that's all I have.
All right. Any questions from the state?
No, Your Honor.
Thank you.
That is the defense's proof.
Okay. All right. Ladies and gentlemen of the jury, if you'll step down the hallway just briefly, we'll talk with the attorneys about legal issues and then get you right back. You can have a seat. And just for the record, Mr. Bland, like we did the other phase of the trial, let Mr. Taylor step around and deal with his decision not to testify. If you raise your right hand and be sworn.
Do you swear to tell the truth, so help you God?
I do.
Mr. Taylor, you understand that at the sentencing phase of the trial, you have an absolute right to make a statement to the jury.
I do.
You also don't have to say anything. You have the absolute right to remain silent.
I do.
And we have discussed that option and the pros and cons, and whether you want to make a statement at this point in time.
Yes.
And based on those discussions, you made the decision that you're not going to make a statement or otherwise testify.
Yes.
And that's your own decision.
Yes.
All right, he can have a seat. And then, Mr. Brand, in terms of the mitigating circumstances that I'd instruct the jury would be the defendant has no significant history of prior criminal activity. Set out the other mitigating factor raised by the evidence consisting of, and what do you contemplate the court instructing the jury there?
Trying to think of how to phrase this, Your Honor.
Right. I mean, excellent student.
I might. what if we said, community involvement, prior acts of service, support system, and educational and personal achievements? That maybe in the ballpark?
All right, community involvement, education, and personal achievement, and what was the other?
Acts of service.
Active service?
Acts of service.
Acts. Does the state care to be heard on that?
No, Your Honor, I think they come under the catch-all.
Okay, and I was planning on setting forth that catch-all about any other mitigating, but then consisting of and then listing.
Yes, Your Honor, I think that would be appropriate under the case law.
And then charge as to in terms of aggravating circumstances in counts 2, the murder was committed against a person less than 12 and the defendant was 18 years of age or older, and the murder was knowingly committed, solicited during the commission of the language there about another first-degree murder.
Yes, sir.
Accurate. And in 3, it would just be that felony murder type language.
Yes, sir.
And 4 would be both again.
Yes, sir.
Well, both
Yes,
again. All right, anything further from the state in terms of jury instruction?
Not without having seen that.
Do you want 10 minutes before we come back with the closing arguments? And I can give you the draft.
Just want to make sure that I don't say anything that's not going to be in the charge.
Yeah.
Okay.
I would appreciate seeing the jury instructions, but we don't need much time.
Okay, all right, give the court just 6 minutes. Maybe.
Court, a brief recess.
The jury instruction.
No, Your Honor.
Mr. Brown, okay. All right, let the jury step down. All right, you have a seat. All right, any closing argument on behalf of the state?
Yes, Your Honor, thank you. Members of the jury, we're down to just about the last decision you'll have to make. And that is, what is the appropriate punishment in this case? I want to start out by saying that yes, the judge will tell you that a life sentence state of Tennessee today is 51 years before parole eligibility. That's a long time. It's a really long time. But contrary to what Mr. Brand said about life without parole being the harshest penalty, the harshest penalty wasn't asked for, the death penalty. So there are 3 punishments for first-degree murder in the state of Tennessee. 1 wasn't on the table. Life without parole is the next step down, and life imprisonment is the minimum sentence for first-degree murder. The state submits that while there might not be a quantitative difference, who knows how long someone is going to live, but there is a qualitative difference. That is, what does the crimes that you have found Mr. Taylor guilty of, what do they deserve? And you can consider, I submit by your verdict, where you mentioned this, you found the aggravating circumstances by your verdict beyond a reasonable doubt. That then allows you, and Judge Dozier will read the instructions, not nearly as long as the first one, that upon that finding, you can consider victim impact testimony. What this man's actions have done to the people who loved Jade Benning and would have loved Ivy and did while she was in the womb. She never got a chance. She never got a chance to know how much she was loved. Mr. Taylor, the judge will tell you, consider mitigating. Yeah. Before this, he had no criminal record. That doesn't mean he is not deserving of life without parole under the facts of this case. And again, going back to everything that you heard during the trial. Apple Denny. Apparently, Mr. Taylor was fine with helping out other people's children. He was a good student. No doubt about that. Very smart man, comes from a very well-educated family. A good athlete. Community service. And like I said, good to other people's children. Not his own. That qualitative difference is that life without parole, the state submits to you, is the appropriate punishment. And you'll really have to decide that and come to on each count. But it is your decision, your collective judgment. There's no, oh, we have to prove this, we have to prove that. Once the existence of an aggravating circumstance is before you, and here we have two, then it is your call. And one of the things, victim impact, and you've got, certainly, his parents didn't raise him to be like this. But the decisions that he has made were his and his alone. His family choose to do so, visit him, so long as they need alive, talk, communicate, whatever. Because there's a saying, where there's life, there's hope. He's going to be alive. He's going to have hope. He's going to have that sense of living and associating and being, granted, not an environment that any of us would want, but it's of his own choosing, his own making. Jade and Ivy's family never have that opportunity. He took that from them 3.5 years ago, February 25th, 2023. He took something that no one is able to give back. And for that, on behalf of the state of Tennessee, submit that whatever hope of freedom that he should have, he does not deserve, and that he should not receive the minimum punishment for these offenses. Thank you very much.
Any argument on behalf of Mr. Taylor?
Thank you. Life imprisonment is an appropriate punishment for Mr. Taylor. And punishment is what it is. It is not a minimum get off easy kind of sentence. It is life in prison. 51 calendar years at best. That's if you make parole at 80, if he's 30 right now. Yes, in opening I said it's the harshest you have is life without the possibility of parole, and there is death penalty, but this isn't a death penalty case. We knew that at the beginning. It's the harshest option you are considering today. And life imprisonment is incredibly harsh. Living in a concrete box for the next 51 years, that is punishment. He's not getting off. He's not getting off easy. You're not letting him go. He's not walking out of this courtroom. Likely for the rest of his life. Now, looking at the jury verdict, it occurs to me that maybe there is some consideration from the jury that you all think Mr. Taylor intended to kill baby Ivy and maybe didn't have the intent to kill Jade. But he knew he was killing her, or some version of that. Obviously, I'm not in the jury room. I don't know if that matters in your deliberation for this part of it. But if we're talking about what are the worst of the worst of the worst crimes that you get the worst of the worst of the worst punishments, this was a long, incredibly detailed, complicated trial. And you guys heard a lot. You can consider all that when you're making your determinations. The reason that we put on some proof about who is Blaise, what was his family like, what's his upbringing like, what's his community involvement like, is there's kind of a, I don't know if it's a saying, it's something that's talked about in work when you defend someone sitting at that table, that we are more than the worst thing we've ever done. We're people. Blaise is a person. He's got a family. He had a great childhood. He did well in school. He was an all-star athlete. Yeah, he did something horrific. Nothing that can happen here is ever going to change that. Nothing. And he's going to spend the rest of his life in prison no matter what. So you all can go home and rest assured that no matter what you do here today, he's going to spend the rest of his life in prison. It doesn't require life without the possibility of parole to send that message, to send that punishment. It's not either we let him off easy or we have to punish him the worst of the worst of the worst of the worst. He's being punished. He's getting the message. But he is not someone who has spent his entire life as a criminal. He is someone who's had a good life, who's done good things. I don't have anything to say about it. Did something terrible. There's, let's call it what it is. When you hear the jury instructions, there's going to be a lot of talk about aggravating and mitigating factors. And I said this in my opening, and I'll say it again. If you find aggravating factors, you don't have to find that he gets life without the possibility of parole. It's just something you can consider. Life imprisonment is punishment. It's life in a box. It's life in a prison. It is a message. It is a lot. It is enough. And we would ask you to return for your sentencing that be the appropriate sentence in this case.
All right, any rebuttal from
Just very, very briefly, it's time to have this jury determine, does he deserve the minimum allowable, or does this crime, these crimes, Mr. Brand argues this is not the worst of the worst. What could be worse than killing your own child and your own child's mother? That is my life without parole. Is an option in this case, and is an option the state of Tennessee would respectfully request you consider and return. Thank you. Thank you, Your Honor.
All right. Members of the jury, you've now found the defendant Blaise Taylor guilty beyond a reasonable doubt of murder in the first degree as charged in counts 2, 3, and 4 of the indictment number 2024A49. It is now your duty to determine within the limits prescribed by law the penalty which shall be imposed as punishment for this offense. Tennessee law provides that a person convicted of a murder in the first degree shall be punished by imprisonment for life without possibility of parole or by imprisonment for life. A defendant who receives a sentence of imprisonment for life shall not be eligible for release until the defendant has served at least 51 full calendar years of such sentence. A defendant who receives a sentence of imprisonment for life without parole shall never be eligible for release. In arriving at this determination, you are authorized to weigh and consider any of the statutory aggravating circumstances proved beyond a reasonable doubt and any mitigating circumstances which may have been raised by the evidence throughout the entire course of this trial, including the guilt-finding phase or sentencing phase or both. The jury is the sole judge of the facts and of the law as it applies to the facts in this case. In arriving at your verdict, you are to consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. The burden of proof is upon the state to prove any statutory aggravating circumstance or circumstances beyond a reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of your verdict. Absolute certainty is not demanded by the law, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the verdict. The law makes you, the jury, the sole and exclusive judges of the credibility of the witnesses and the weight to be given the evidence. The prosecution has introduced what is known as victim impact evidence. This evidence has been introduced to show the financial, emotional, psychological, or physical effects of the victim's death on the members of the victim's immediate family. You may consider this evidence in determining an appropriate punishment. However, your consideration must be limited to a rational inquiry into the culpability of the defendant, not an emotional response to the evidence. Victim impact evidence is not the same as an aggravated circumstance. Proof of an adverse impact on the victim's family is not proof of an aggravating circumstance. Introduction of this victim impact evidence in no way relieves the state of its burden to prove beyond a reasonable doubt at least one aggravating circumstance which has been alleged. You may consider this victim impact evidence in determining the appropriateness of the sentence only if you first find the existence of one or more aggravating circumstances as has been proven beyond a reasonable doubt by evidence independent from the victim impact evidence. Count 2, statutory aggravating circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances, which shall be limited to the following. 1, the murder was committed against a person less than 12 years of age and the defendant was 18 years of age or older. And 2, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit, or was fleeing after having a substantial role in committing or attempting to commit any first-degree murder. Knowingly means that a person acts knowingly with respect to the conduct or circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Members of the jury, the court has read to you the aggravated circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravating circumstance in deciding whether imprisonment for life without possibility of parole would be appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider as previously indicated any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. The defendant has no significant history of prior criminal activity, and 2, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character, any aspect of the circumstances of the offense favorable to the defendant, which is supported by the evidence, consisting of A, community involvement, B, education and personal achievements, and C, acts of service. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance or that you agree on the same mitigating circumstance. Count 3, the felony murder involving Jade Benning, statutory aggravating circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury, but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances, which shall be limited to the following. 1, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit or is fleeing after having a substantial role in committing or attempting to commit any first-degree murder. The definitions of knowingly, intentionally, which apply to this offense have been previously explained to you in these instructions, and you should refer to those definitions as they apply to this offense. Members of the jury, the court has read to you the aggravating circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravated circumstance in deciding whether imprisonment for life without possibility of parole would be an appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. 1, the defendant has no significant history of prior criminal activity, and 2, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspects of the defendant's character or any aspect of the circumstances of the offense favorable to the defendant, which is supported by the evidence, consisting of A, community involvement, B, education and personal achievements, and C, acts of service. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance, or that you agree on the same mitigating circumstance. Count 4, felony murder involving the victim, the unborn female child of Jade Benning. Statutory aggravated circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury, but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more statutory aggravated circumstances, which shall be limited to the following. 1, the murder was committed against a person less than 12 years of age and the defendant was 18 years of age or older. 2, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit, or was fleeing after having substantial role in committing or attempting to commit any first-degree murder. Definitions of knowingly and intentionally which apply to this offense have been previously explained to you in these instructions, and you should refer to those definitions as they apply to this offense. Members of the jury, the court has read to you aggravated circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravated circumstance in deciding whether the imprisonment for life without possibility of parole would be appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. 1, the defendant has no significant history of prior criminal activity. 2, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character or any aspect of the circumstances of the offense favorable to the defendant, which is supported by the evidence, consisting of A, community involvement, B, education and personal achievements, and C, acts of service. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance, or that you agree on the same mitigating circumstance. The defendant has not taken the stand and testify as a witness during the sentencing hearing, but you should place no significance on this fact. The burden is on the state to prove any aggravated circumstance or circumstances beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. You will be provided a verdict form consisting of 6 pages. You have 2 sentencing options to consider on each count, and you are not required to deliberate on these sentencing options in any particular order. The options are as follows. Verdict, life imprisonment or life imprisonment without possibility of parole. If you do not unanimously determine that a statutory aggravating circumstance has been proved by the state beyond a reasonable doubt, the sentence shall be life imprisonment. You will write your verdict upon the enclosed form attached hereto and made a part of this charge. The verdict shall be as follows. We, the jury, unanimously find that the punishment shall be life imprisonment. If you unanimously determine that a statutory aggravated circumstance or circumstances have been proved by the state beyond a reasonable doubt, You shall, in your considered discretion, sentence the defendant either to imprisonment for life without possibility of parole or to imprisonment for life. In choosing between the sentences of imprisonment for life without possibility of parole and imprisonment for life, you shall weigh and consider the statutory circumstances or circumstances proven by the state beyond a reasonable doubt, and any mitigating circumstance or circumstances. In your verdict, you shall reduce to writing the statutory aggravated circumstance or circumstances so found, and shall return your verdict upon the enclosed form attached hereto and made a part of this charge. The verdict should be as follows. We, the jury, unanimously find that the state has proven the following listed statutory aggravated circumstance or circumstances beyond a reasonable doubt. Here on the verdict form, you would list the statutory aggravated circumstance or circumstances found. You shall then indicate on the enclosed verdict form either we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole, or we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. The verdict must be unanimous and signed by each juror. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. You will be provided with a form for all possible sentences in this case. The jury will check the appropriate verdict on the form for each count and complete the form as directed, and each juror will sign the verdict form. The other forms are to be left incomplete and unsigned. Your foreperson will preside over your deliberations, and when you have reached a verdict as to the sentence, you will return to the courtroom and your foreperson will announce it. You must not imagine that the court has any opinion in regard to the facts. It is your duty to find them, and have attempted to read this charge to define to you the law without indicating any opinion about the facts whatsoever. Members of the jury, the charge in this case is herewith handed to you together with the verdict forms for the punishment for each count and the exhibits. You may now retire and consider your verdict. You can step down the hallway with the court. Anything further from the state?
Judge, I know that need to be a hearing, sentencing hearing. I don't know if we had a date, we might also be looking at our
Yeah, in
calendars.
terms of merger and count one,
And
whatever happened.
yes, Your Honor, and
And we can look at like the week of the August 3rd, like the 5th maybe, or somewhere around there. Discuss that.
yes, that's all.
Anything further on the jury charge, Mr. Brand?
No.
Okay. All right, we'll need a recess.
Court to the recess.
Oh, yes,
All right, the court staff's been made aware the jury's arrived at a decision in terms of the punishment phase, so we'll let them step down and announce it. And was there an agreed on date on any sentencing issues?
I think the clerk is looking at possibly a date in September.
You want to do the 9th? Check that, let us know if it's not good. All right, all right, juror number 7, you are still the foreperson? And the jury's arrived at a verdict in terms of the sentencing issue?
Yes, ma'am.
All right, if you would, please, ma'am, stand and announce that verdict from the jury verdict form.
We, the jury, unanimously find that the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. 1, the murder was committed against a person less than 12 years of age and defendant was 18 or older. 2, the murder was knowingly committed, solicited, directed, or aided by defendant while defendant had a substantial role in committing first-degree murder. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life.
And that is
count 2.
Okay.
For count 3, we, the jury, unanimously find the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. 1, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting any first-degree murder. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. And for count 4, we, the jury, unanimously find that the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. 1, the murder was committed against a person less than 12 years of age and the defendant was 18 or older. 2, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing any first-degree murder. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life.
All right, and that's signed by each of the jurors?
Correct.
All right, you can turn that document into the court staff. Anything further from the state?
No.
Anything further on behalf of Mr. Taylor?
No, Your Honor.
All right, ladies and gentlemen of the jury, I appreciate very much your service for the last week plus to the court and your community. You'll be discharged from this case and from your jury service. You can step down the hallway with the court officer. All right, Mr. Taylor, you have a seat. Mr. Taylor, you've heard the verdict in terms of the punishment. Counts 2, 3, and 4 that the jury's imposing a life sentence in each of those counts. That verdict will become the judgment of the court. We'll set this on 9/9 for any sentencing issues, merger issues. And if that date doesn't work, Mr. Brand, just let us know in advance.
Yes, thank you.
All right, let Mr. Taylor step in the back. will be adjourned.
Yeah.